Welcome to another episode of Breaking History, the podcast of the Supreme Court Historical Society. Today's episode is a series on trailblazing women in the office of the Solicitor General, government advocates before the Supreme Court. We are so lucky to have with us several of those trailblazing women advocates. These women were among the first hired by the office of the Solicitor General. The Office of the Solicitor General, known as OSG, is an office in the Department of Justice that was created by statute in 1870. OSG is a relatively small office of 20 attorneys, with the Solicitor General heading the office, 4 deputy Solicitor Generals, and about 15 assistants to the Solicitor General. It is the office where most of the government lawyers who regularly argue before the Supreme Court work. But that was not always the case. Until 1972, it was only male lawyers who worked in OSG, not women. But there were government lawyers who were women who were also arguing regularly before the Supreme Court. Our trailblazing guests are the first women hired in the 1970s and 1980s in OSG. Carolyn Corwin, Elinor Stillman, and Barbara Etkind. We'll be hearing more about their careers and introductions when they share their experiences. We also have some additional guests who will be joining virtually. We're going to have them share with us some of their recollections about arguing in the Supreme Court, the justices who questioned them, the Solicitor Generals who hired them, and the institutional role of the Solicitor General vis-a-vis the Supreme Court, the White House, and other aspects of government. Our guests also will talk about their career choices that led them to the Office of Solicitor General and the legal practices that followed. My name is Beth Brinkmann. I'm honored to serve as podcast host because the women blazed the trail for me to join the Office of Solicitor General in 1993. I was the 10th woman hired as an assistant in the office. I spent 8 years there arguing Supreme Court cases, and I met most of these women during those years and heard some of their stories. But I learned even more preparing with them for this podcast. I'll be adding a few of my own recollections along the way. Before we begin, I want to thank the Supreme Court Historical Society, and in particular Claire Cushman, for indulging me with this project. I am a strong supporter of the Supreme Court Historical Society. I invite you to also become a member or renew your membership so that we continue to learn from history. Please visit the website for the Society. It's supremecourthistory.org. And you'll find a trove of interesting programs there, including videos by justices, academics, advocates. And there are also information about our civics education programs, such as the Hometowns Project. That's where the Society partners with local federal district courts across the country to provide an immersive, in-person civics program for high school students. There's much more. So please visit the site and join the Society. We're going to start now with a few highlights I put together about women Supreme Court advocates that predated our guests here. This should provide some historical context for the careers of these OSG women who will be speaking with us. It was 1880 when Belva Lockwood argued as the first woman before the Supreme Court. Belva argued a second case 26 years later in 1906, both when she had her own private practice. Other women did not start arguing before the Supreme Court until 1910. Across the next 60 or so years, approximately 270 women argued before the Supreme Court. We want to give a big thanks to Marlene Tressman for doing a lot of research to put together those numbers. 4 women in that group stand out. Each of them argued more than 20 cases before the court, and each of them was a federal government attorney. Mabel Walker Willebrandt was in the Department of Justice focused on prohibition and federal tax cases. Helen Carlos was in the Department of Justice Tax Division when that was first created. Bessie Margolin was in the Department of Labor. And Beatrice Rosenberg was in the appellate section of the Criminal Division of the Department of Justice. Combined, those 4 women argued more than 100 cases for the federal government before the court. Despite that extensive Supreme Court advocacy for the government, none of the women was invited to join the men in the office of the Solicitor General at that time. OSG hired its first woman assistant in 1972, Harriet Shapiro. We all worked with Harriet in the office. She argued Supreme Court cases for the government for a dozen years. She then decided to shift her focus to writing and review responsibilities in the office and served there for a total of 29 years, retiring finally in 2001. Harriet passed away in 2022 at the age of 93. Harriet did not keep count of her arguments or the briefs she wrote. We had to count them up. But she did keep count of the number of women attorneys who joined the office as assistants and a few as deputies also. I know each of you has shared with me particular recollections of Harriet. I just thought we'd add a little before we framed, as a framing before we went on to individual recollections of your own careers there. Carolyn, you had a particular, I know, relationship with Harriet.
Well, I loved Harriet. She was very down to earth, very approachable. But a wonderful thing about her was that she really kept track of the history, the continuity of women in the office. I think we all knew from Harriet which number we were, because she told me at least I was the 6th woman hired as an assistant at the office, and I think she told every woman after that and before. Mm-hmm. And then after I left the office, Barbara and I had overlapped in the office, and we had both left. But Harriet would make a point of inviting us back to have lunch with her and whoever had been hired since we left, which women were there. And I clearly remember at least 2 of those lunches, one where we were introduced to Christine Husson and the other Amy Wax also. And then a few years later, I met you, Beth, at one of those lunches. So it was a wonderful way to understand that there was a line of continuity there with women in the office, to feel that support and some a little bit of sisterhood.
Thank you for that story, Carolyn. That was a very important and special role that Harriet played in the office. And it reminded me also that later, when the first woman became the Solicitor General, now Justice Kagan, the women had a dinner for her, and I think one of our other guests, Kay Oberly, helped plan that. I remember it distinctly. We did not need a very big room. We had a very nice dining room over at the caucus room of the day, and I think Solicitor General Kagan very much appreciated that and the support of the women in the office. We have some historic artifacts about Harriet from a retirement event that we had for her, and I think we're going to try and share those online. There's a photo of the masthead and of her editorial board when she was editor-in-chief of the Columbia Law Review in 1954. There's also some correspondence that she had then with Justice Felix Frankfurter, who had very strong views about citation format. There's a photo of the Solicitor General's office, the attorneys in the office when Harriet first started. And then there's perhaps my favorite. There's a photocopy of the printed form, which Harriet's husband used to move her to be admitted to the Supreme Court in 1972. Mm-hmm. When they filled out that printed form, they inserted a handwritten S right before the word he, to be precise, because the form was inaccurate and it had to be corrected because the attorney being admitted was a she, a woman. Thank you. After the Solicitor General's office hired its first woman assistant to argue Supreme Court cases, Harriet Shapiro, it was 4 years until it hired the next one. We are pleased to have with us that attorney, Sarah Sun Beale. Sarah served in OSG from 1977 to 1979. Welcome, Sarah. Thank you for joining us. You argued 5 Supreme Court cases while you were at OSG and briefed many more. I know that the last one you argued was a unusual quiet title case. Could you share some recollections about that argument with us, please?
I'd be delighted to. It was a difficult and complicated and really strange case. The case had been initiated by a Bureau of Indian Affairs employee who worked very, very, very closely with many tribes and who was a passionate advocate of their interests. And he found some records, some historic records, indicating that land now on the east side of the Nebraska River, the dividing line between Nebraska and Iowa, had once been part of the reservation. And the river had moved, and Mr. Veter's theory was that the river had moved by avulsion, and hence all of that land on the east side of the river belonged to the Indian tribe. And it was quite a large parcel that now was owned by individuals and corporations and the state of Iowa. And so the tribe claimed that land. And during the course of the litigation, Mr. Veter focused on various historical records, and he was passionate, including the time of his argument in the Supreme Court, that he had really won that case on these various historic records. But along the way, notice was drawn to an unusual statute, 25 U.S.C. 194, that said in any case between a white person and an Indian, if the Indian can show previous possession and title, then there's a presumption of the Indian's ownership. Why did that statute exist? Well, it existed because at the time of its passage, Indians could not be sworn as witnesses. Indians had no legal representation, and white people were basically stealing their land, and there was insufficient protection of them. So they got this kind of significant advantage in the litigation to make up for that disadvantage. Fast forward to the time in question, the litigation was between the tribe, not an Indian, and these various owners on the eastern side of the river that, as I think I just said, included the state of Iowa, various corporations, many individual landowners. And at the time the case was tried, that statute didn't have the kind of central importance it gained during the rest of the litigation. And no one proved the race, for example, of the various owners on the eastern side of the river. And as noted, it didn't involve a case of an Indian versus a white person. In fact, the tribe, not an Indian, was represented not only by Mr. Veter, but by the Office of the Solicitor General, because the United States had a kind of trust relationship here. So it was a pretty big stretch from the clear application of the statute. Also, the defendants all took the position that the river had moved gradually by accretion. Think back to your years in first-year property. You may remember that if a river moves by accretion, the border between two properties moves with it. It's only if it moves by this very dramatic avulsion that the border stays the same. So by the time we get to the Supreme Court, it's necessary for me to argue that an Indian on the one side includes the tribe and includes the United States representing the tribe, and a white person includes all of the individual landowners, race unproven, but none claiming to be an Indian, all the corporations, and the state of Iowa. And that was pretty tricky. And we argued that federal law rather than state law governed these the determination of what counts as accretion and avulsion. And honestly, I couldn't find a big difference between federal and state. There's not a lot of federal law on what counts as accretion and avulsion, but of course we argued it was a federal definition. And when I stood up, they were so relieved to have someone who actually understood all of the issues in the case, and everyone in the courtroom seemed thrilled. I received more compliments on that argument than any other, and I think it was because I was actually prepared to and did speak about these difficult issues in the case. I did get one question that I should have been prepared for, and at the time I was in the office, we did not do moot arguments. And I'm sure that this is a question that I would have received had we done a moot. So again, our argument was an Indian includes a tribe or any representation of Indians and Indian interests, and a white person is a non-Indian. And a non-Indian then would include the state of Iowa. And one of the justices asked me, aren't there any Indians in the state of Iowa? Again, admitted I should have known the answer to that question. I had no idea, and I just said, I'm not sure, but there will be if we win this case. And my strong recollection is every member of the court kind of chuckled and nodded, and everyone in the courtroom did, so I got off the hook lightly on that. But it was such a complicated argument, and even imagining how the court would respond to that kind of white person and Indian statute now is interesting mental exercise.
That's a classic description of a Solicitor General federal government argument in the Supreme Court. Sarah, no doubt. The Supreme Court really looks to the Solicitor General's office for that explanation of the relationship between federal and state law, for example, and also, of course, as you emphasized, the statutory text.
Right.
Particularly in the Solicitor General's office, I think across the years, there are many cases involving the rights of Native Americans. My first argument was one. And you're dealing with a statutory text that refers to Indians and people by race. And that is the text that you're discussing. So it's a very unusual circumstance to be in. And as you also mentioned, there's a particular role for the United States aligning with the Native American tribes in many instances.
Right.
Thank you for that. I know you had another case that brought you an unusual experience of diplomacy, I would say. It wasn't a case you argued, but it was a case that's on the Supreme Court original docket. Could you tell us what that involved and also share with us that original docket role that the Solicitor General plays for the Supreme Court?
I'd be happy to. Litigation went on for decades, and I believe is still continuing today, on the division of the water of the Colorado River. And because it involves disputes between states and the allocation of water between states, it was an original case in the Supreme Court. And those original cases, and this is the only one I worked on, but the original cases in general do require the assistance of a special master, and they require fact-finding, which, as I think this audience would understand, is not something that the Supreme Court ordinarily does.
And just to be clear, Sarah, you're saying because when it's an original case, it originates in the Supreme Court. There's been no trial court, no court of appeals,
Correct.
Right? Mm-hmm.
Thank you. And I should have made that clear. So it originates in the Supreme Court. There is no lower court. The Constitution views the idea that two sovereigns against one another, two sovereign states, should have the dignity of being themselves in the Supreme Court. And this case had been going on for decades. The special master had issued something like a 500-page report, and details continued to be worked out and disputes continued to arise, and that's where I came in. So I was minding my own business in my office on a Friday afternoon when Deputy Larry Wallace dropped by and said, could you just take a little something on? I don't think it's going to take much time. And I said, well, sure. And the next thing that arrived on my desk was some of the most recent documents in this original case. And so on Monday morning, I think it was too late to do anything on Friday, I called someone in the case and I said, I've just picked up this case. And I think the person on the other end of the line dropped the phone. And when he picked it up again, he said, this case has been going on for years. All the lawyers here have been litigating this for many years. You have just picked this up? And I said, yes, that's right. And if you think about the tenure of a typical assistant in the Office of the Solicitor General, it doesn't, in general, it doesn't go on for decades, right? Young lawyers come in and work there for several years and leave, as I did. So it wasn't so unusual that in our office this had been picked up, although people in what we then called Land and Natural Resources had been working on it for a long time in the Interior Department representing the tribes' interests, Bureau of Indian Affairs. And the reason, Beth, you probably asked me about this is, again, because it involved fact-finding and because it involved, from our point of view, the interests of the tribes, and the question whether the allocations needed to be adjusted, I went with some other lawyers from the Justice Department and the Interior Department out to speak to the tribes who were, at that time, there was very little trust between the tribes and the government attorneys. There had been, I think, many years of unsatisfactory dealings. So we flew, I think, to Phoenix, and then we took a tiny little plane to a little postage stamp kind of landing spot on one of the tribal reservations, and we trooped in to this meeting house where the tribal leaders were to listen to us. And for about 45 minutes, we all sat in the hall where they decided whether to even listen to us. So there were such hard feelings. And it was in that same case that the tribal leaders had refused to let any representatives of the federal government onto the tribe for tribal lands for purposes of determining the needs for water at that point. And the federal employees were limited at that point to what they called a windscreen survey, meaning they drove on public roads and stopped the car frequently and got out and used binoculars to try to see what was going on the tribal lands to try to get a sense of what the water needs were. So again, this was kind of an opening move to try to develop more rapport and get some direct contact with the lawyers who were going to be working on this case. My tenure in the office was pretty short. I got handed on to someone else who probably made a similar call saying, I've just picked up this case, setting off shockwaves among the other lawyers. But it demonstrates a kind of little facet of the Supreme Court's work, which does involve the original proceedings, and a piece of that work on the original proceedings is handled by lawyers in the Solicitor General's office, although the bulk of the work, to be sure, is shouldered by those people who introduce evidence and so forth before the special master.
That description of the diplomacy that you engaged in with the tribal leaders is a unique experience that I think many in the Solicitor General's office ultimately have to develop, perhaps not with the type of on-site visit that you made, Sarah. In my day, I remember distinctly being very honored when tribal leaders came to meet with us. And we would meet with what's now called the Environment Division, which used to be called, as you mentioned, the Lands Division. And it was a very moving experience. I have to say, I think diplomacy comes in often with the assistance of the Solicitor General also, because you're often dealing with the lawyers who handle the case in the Court of Appeals and the various divisions, whether it's criminal, civil, lands, tax, antitrust, all of those divisions, and also certainly the amazing career lawyers, not only in the appellate divisions, but in the trial courts. And so you gain that experience of diplomacy and working with the lawyers who've developed the record and all. And the OSG usually doesn't get involved until it gets to the Court of Appeals and whether a decision's being made to, and when the decision is made whether to appeal. But you were assigned a case in the trial court, a very interesting case. We'd love to hear about that.
So again, I was playing a secondary role in as you say, a very unusual case. The department received information that a magazine called The Progressive was preparing to publish a story about how easy it was to make an H-bomb with what the national security folks said was sufficiently accurate information that it could be very, very dangerous if this information were published. And so they filed for a temporary restraining order in the district court to stop publication in advance. And from a First Amendment perspective, that was an extraordinary kind of relief to seek. And it was thought that the case was likely to move up extremely quickly, maybe a little like the Pentagon Papers, to just pop up very quickly. And so it was thought that someone from the Solicitor General's office should sit in on the various meetings and have some familiarity with the nature of the case and the nature of the evidence and the arguments. And so I was tagged to sit in on those various arguments. I'll jump ahead just to say that another publication came out with similar information, and this case was eventually dismissed, so it never worked its way on up into the Court of Appeals and the Supreme Court. But I sat in on several meetings in what I think is the most secure room in the Department of Justice, and the strongest recollection, I have a couple of very strong recollections. One of which is that the walls themselves of that room were about 3 feet thick, right, in order that no one could beam in and hear what we were discussing. And when they closed the door, and no one had cell phones or anything in that, anything of that nature, it gave one an extremely claustrophobic feeling. And how would we get out if the door was stuck? And I'm not ordinarily subject to thinking about those things, but that was a really very secure location. And the technical details that were discussed were at an extremely high level. And the discussion went back and forth. And I was, of course, trying to follow this to understand in case the case should go up. But it became pretty clear to me as the discussions ensued that I would be unable to give a really clear account of why this particular piece of information was so significant in terms of the way that H-bombs are constructed. And I began to have, I wouldn't go so far as to say nightmares, but fears that if things really cranked up and somebody really was trying to get this information to work against the interests of the United States, and they picked me up and tried to get the information from me, I realized they could torture me and I would not be able to give anything up. So I was safe from that point of view. But again, I think it shows a part of proactive thinking in the Solicitor General's office to what might be a really important, really fast-moving case that in this instance did not suddenly fast-track up to the Supreme Court. But as a prior restraint on the press, it certainly could have. But it fizzled out.
That was a very prudent decision to involve the Solicitor General at the outset. And as you pointed out, that sometimes does occur, a couple times I'm aware of, but not often. And certainly pretty much a classic prior restraint that I think you're right, that would be going straight up to the Supreme Court. I wanted to just turn now for a moment to talk a bit about your career and how you came to work in the Solicitor General's office. What did you first do? I think you went to the University of Michigan Law School. What did you do after you graduated?
So I didn't have a really good plan. To jump ahead, I eventually went into teaching, and when students would ask me what my plan was, I would say it was the cockroach plan. And they would look puzzled and say, I didn't know they had a plan. And I would say, that's right, I didn't really have a plan. So I was looking to do something in driving distance of Ann Arbor, where Michigan is, for a couple of years while my husband was finishing up graduate school. And then we were going to decide what was next. So I went for a year to the largest firm in the state of Michigan because I thought that would give me options. And then I was hired to clerk that second year for Judge Wade McCree on the Sixth Circuit. And he had said, I think maybe I could find you a district court clerkship for that first year. And I probably wasn't wise when I said, well, I may end up going into practice, so maybe I should try that out and see how that works. So I did a year in private practice, a year with the judge, and then it was the time in our joint planning to do whatever was next. And I didn't really know what I wanted to do. Again, got that cockroach thing. So I had some offers to begin teaching at, I guess, Ohio State and Wisconsin and Illinois, and that didn't seem like, in fact, Judge McCree said, why do you think you're ready to teach just 2 years out? And I thought, probably not. And I wasn't very interested in the firm that I had been with in Detroit or the one I'd summered with in San Francisco. Private practice didn't really interest me. So the crumb that the cockroach followed was the form for the honors program that got distributed to all the law clerks. So I filled it out.
And that's the honors program for the Department
The
of
honors
Justice.
program. The honors program. And I filled it out, and I got extremely lucky. Someone I knew slightly from law school came out with an assistant attorney general to do the interviews, and he called me in advance, and he said, I can set you up for 20 minutes with the great man, or I can take you out to lunch and tell you how things really work. I said, I'll take the lunch. So he looked at my form. He looked at my form, and he said, so you think you might want to do criminal work or maybe civil rights? I said, yeah. He said, you don't want to go to the criminal division or the civil rights division and go to Main Justice because so much of the interesting work is done in the U.S. Attorney's offices. The best office, and this is the first time I'd heard this idea, the best office in the Justice Department is the Office of the Solicitor General, but they are not going to hire you out of the honors program now. He said the second best office is the Office of Legal Counsel. So he told me about both of those two offices. And he said, I think you'd really like the Office of Legal Counsel. It does a lot of constitutional work and difficult stuff. And I said, yes, that sounds great. And he said, you have to put it as your first choice or you won't get it. I said, that's my first choice. And a couple of days later, I got a call from Antonin Scalia, then the head of that office, offering me the position. And so I said, great. And
I have to say, I think that just the fact that a brilliant mind like Justice Scalia, before he went, on the bench from the Supreme Court, one of the jobs he had was head of the Office of Legal Counsel, shows what an amazing office it is. Could you just describe slightly what it does compared to the Solicitor General's office? I mean,
Sure.
The Solicitor General's office, as we all know now, is all the lawyers who litigate in the Supreme Court and work with all the other components. But the Office of Legal Counsel also handles very similarly complex constitutional legal issues, but in a different framework.
That's a really good starting point. So the Office of Legal Counsel handles a variety of extremely complex and difficult constitutional and statutory issues. It resolves differences between different divisions of the Department of Justice, between different departments of the government. I had one case where the Department of the Defense was arguing with the Department of Labor about whether the general labor standards applied to civilian employees who had certain kinds of positions on Department of Defense installations, for example. It does the Attorney General's formal opinions. So none of it is
And you
litigation.
also advised the president, the White House,
Absolutely.
on
Absolutely.
complicated issues.
To
What
the
what
office of the
led you?
president and the president.
Mhm. What led you from, that amazing job advising the president in doing, analysis of legal opinions for the Attorney General? What led you from that office over to the Solicitor General's office?
I liked the structure of what the Solicitor General's office did. I found that I was much better suited to it. So in OLC, you never knew whether anything was ever going to happen on most of the things you worked on. So we might work on things for months, and then they would decide not to do whatever initiative it was. And things went on for a long time, and it was pretty unclear, at least to me as a new lawyer, exactly, almost everything was unclear, or it wouldn't have made it to us. And so was our role to say, you can't do it, there's not clear authority, or you can do it because there's no clear authority saying you can't.
There was a change in administrations that played a role.
Oh,
I
there
think,
sure
in your
was.
transition.
Oh, there
What
sure
happened
was.
with that?
It sure was. Well, almost everything that had been planned got dropped entirely, right?
And what was that change in administration? Just to put us in
Jimmy Carter beat
context.
Gerald Ford. Jimmy
Mhm.
Carter beat Gerald Ford.
And
And
who did
so
he make the
Antonin
solicitor?
Scalia was out, and Griffin Bell became Attorney General, and Griffin Bell's former law clerk, John Harmon, was brought in as a temporary acting head of the office. He was way too junior, I think, and hadn't really been doing he was in Couder Brothers, I think, in Europe. Judge Bell, as we still called him, really liked John Harmon. They had breakfast together every morning with a small group. And it was so interesting. When Scalia was head of the office, he basically tried to get rid of almost everything. It was, that's not important. Those people, someone else can handle that. Harmon, coming in from private practice and having a different attorney general, had meetings. He said, now, if we turn things around really fast and we do a really good job, they'll bring us more work. Right? So it was a different point of view of what turf. And at that time, Assistant Attorney General Scalia wanted only things that he thought were personally interesting and really important. And he would spend a long time himself working on those things. And it was a really different mindset under the Bell.
Well, when President Carter was elected and brought in Griffin Bell as Attorney General, there also was a decision made to bring in a new Solicitor General who
Correct.
You already knew.
I did. So Judge Wade McCree, for whom I had clerked in Detroit, was named Solicitor General. So like Thurgood Marshall before him, he resigned from the Court of Appeals to become Solicitor General. And there was a lot of speculation that, like Thurgood Marshall, Judge McCree, would be appointed to the Supreme Court. He certainly never told any of us, his clerks or anyone in the office, anyone that I knew, that he had been promised that. And President Carter did not have a chance to appoint someone else. Judge McCree, when he left that office, went into teaching. But from my point of view, in terms of an entry point, there was a kind of natural attrition. With the change of administration, several positions opened up in the Solicitor General's office. And I thought, coming from OLC, with pretty good recommendations from there, that I would have a shot at it. And I thought I'd done a good job as Judge McCree's law clerk and that he liked me a lot. And I got the offer. So I did move over to the Solicitor General's office. Go ahead.
Go. No, please.
I loved the structure. I can still remember Danny Friedman, the first deputy, training me initially. This is how you think about an op. This is how you think about an appeal rec. This is how you think about a en banc. This is how you think about a cert petition. And and then there was going to be a decision made, and there were deadlines, and things happened. And I loved it. I I
So
really loved it.
So you were the first of, maybe not the first, you were one in a line of, I think, attorneys who came from the Office of Legal Counsel to the Office of the Solicitor General.
Mhm.
And I know that you played an absolutely critical role in the long-term future of the Solicitor General's office because you recruited a particular lawyer to OSG. Who was that?
So Ed Needler had been one of my closest friends in OLC. When he and Lynn moved, we helped them move. When we moved twice. He helped us move. I've still got their chicken salad recipe. So as I said, I loved the office, and I was getting ready to leave, and I kept saying to Ed, this is even better than OLC. You would like this better. You should apply. And I think the more he thought about it, the more he thought, as we all saw over many years, that he was so well suited to that office.
He was very well suited to that office.
So
And
the day I left,
Mhm.
right, the day I left, he moved into my old physical office. Now all the furniture was gone because the day I announced I was leaving, the little Post-it notes started showing up. I had pretty good furniture by then on the desk and on the bookcases and on the desk chair. And when I left, all the oldest stuff, I think a lot of it was even like metal and so forth, not even wood. So he got the dregs. But he was my, so to speak, my replacement. Obviously, far surpassing anything I did. Right.
Generations of assistants to the Solicitor General were mentored by Ed, and we all owe you a huge debt of gratitude. For the audience, you probably mostly know this, but Ed Needler went on to serve, I think, 46 years in the Office of the Solicitor General. He argued 160 cases, more than any modern advocate. And the most remarkable thing occurred in the Supreme Court chamber last year when he retired in 2025. When Ed finished his last argument and the case was over, the Chief Justice called Ed back up to the lectern and thanked him for his amazing years of service because of the special relationship of the Solicitor General and the Supreme Court. The Supreme Court benefits so much from someone with that just experience and credibility that Ed Needler had. And then applause broke out in the chamber. That just doesn't happen in the Supreme Court. And on top of that, there was then a standing ovation for Ed, and the justices joined in it. So, Sarah, that might be your, lasting legacy. Let's just quickly, I guess, turn to when you left. I know you became a law professor then.
That's right. I was very fortunate to take a position at Duke Law School, which, again, I absolutely loved, and was there for 45 years until my retirement in 1974. I'm emerita there now. I got to teach exactly the classes I wanted to teach, including federal criminal law, which is built on my work in the SG's office and beginning with my clerkship with Judge McCree. Those were the cases I loved the best.
Didn't you also get to argue another case in the Supreme Court?
I did. Again, this cockroach theme keeps popping up. I was minding my own business in my office, and I got a call saying, would you like to do a Supreme Court argument? I said, why are you asking? Well, so a inmate named Joe Libretti's case cert had been granted, and Mr. Libretti and his federal public defender, to put it mildly, did not get along well. Mr. Libretti was a very smart guy and very opinionated, hated her. And she didn't have very warm feelings towards him either. So Mr. Libretti called or wrote his childhood friend who worked at Duke Medical Center and said, I need a different lawyer. This childhood friend began doing some kind of research and came up with my name. And honestly, I actually was the perfect person. So it was forfeiture, which was in our federal criminal law casebook. It was to it was right up my alley substantively. And as you say, I had experience as a Supreme Court advocate. So I arranged a call to Mr. Libretti in prison, and I asked him to explain why he really wanted to do this. And I spoke to the federal public defender, and I filed a motion on his behalf to have me appointed, and the court granted it. So it was, again, just a chance thing. If his friend had been somewhere else in the United States, he probably would not have come up with my name. And
That's so often.
Yeah, right. It was just by chance, and I knew that I couldn't handle it all on my own from Duke Law School, that I would need to have someone associated with a firm and with some kind of infrastructure. And I thought about many wonderful former students who were in private practice in D.C., and I thought, that's kind of clunky. And then a bolt of lightning hit me, and I asked my brother, who was number one in his law school class and did a lot of appellate practice, if he would take it on. So I got to actually work with my younger brother on the case, which was a wonderful experience. And the research assistants I had working for me at the time were great. So we didn't win, but it was a great experience. And for many years, I remained in email and mail correspondence with Mr. Libretti. And one day there was a knock on my door. Again, it was in the summer. Nobody was around. And I said, come on in. And he said, I bet you don't, the man standing there said, I bet you don't know who I am. I looked at him, I thought, this is supposed to be one of my former students come back. He said, I'm Joe Libretti.
Wonderful. Wonderful.
And he ended up going to law school.
Well, thank you, Sarah. Those early days sound exciting and challenging. We appreciate you sharing your recollections with us.
Thank you for giving me the chance. I appreciate it.
Our guest, Elinor Stillman, was hired by the Office of the Solicitor General in 1978. She was the fourth woman assistant and argued 11 Supreme Court cases over the next 5 years. Elinor, what are some of your recollections about arguing before the Supreme Court?
Well, one of the arguments that stands out in my memory was railway labor executives against Gibsons. It was not a case that I briefed. One of my colleagues briefed it, but he was going to be arguing a different case at that time, and they gave it to me. We called them pickup arguments.
Yes.
And it was a case that involved the bankruptcy of the Penn Central Railroad. And basically, what we were doing was defending the constitutionality of the Staggers Rail Act. In the Staggers Rail Act, Congress had devised a specific sequence of who was at the top of the line, head of the line, to get payments from the assets of the railroad.
If this is in a bankruptcy situation?
Yes, yes, it was. And they put the railway labor employees first, ahead of the creditors and the bondholders, which was not the usual procedure. And in the course of the argument, Justice Powell asked me, when it was devising its position in this case, did the government consider the position of the creditors? And I said, yes. And he said, well, I wonder, did the government want to encourage people to invest in railroads, or did they just want to take over the railroad? And I was taken aback by this question. To the question about whether we considered the interest of the creditors, I said yes. But to the other question about the government taking over, I had no idea and I just said, I don't think I'm in a position to argue the government's position in that case.
I think we all have experienced that circumstance where the Solicitor General has a particular expectation placed upon it by the court, because the Supreme Court expects and asks you to represent the views of the entire federal government when you're up there.
Yeah.
So it is a difficult situation sometimes. Tell us about what happened when the ruling came down.
Well, the ruling came down, and the government's position and the position of the creditors and bondholders won. And in that day, there was no getting things off the internet. And we, as usual, sent over to the court a messenger to bring back a copy of the opinion. And I then got a call from one of the lawyers for the creditors in Chicago. He was in Chicago. And he said, I heard that the decision came down. What is the rationale of the opinion? And I said, well, everybody thought they would decide the case on the basis of the takings clause of the Constitution. And I said, well, they decided it on the uniform laws of bankruptcy terms of the Constitution. And there was a long, they said that Congress did not abide by the principle of a uniform law of bankruptcy because they had, for just this case, decided that the employees came first. And there was a long pause, and then the lawyer in Chicago said, we almost left that argument out of the brief.
There you have it. A lesson in Supreme Court strategy right there. I know you also argued a case involving the Clean Water Act and the Defense Department.
Yes. And this was a case involving the U.S. Naval Atlantic Fleet practiced its firing of cannons and so on the island of Puerto Rico, Vieques Island. And they would be out there on their ships and they would send munitions over and it would land, some of them landed in the water right next to the island. And the Pollution Control Act made illegal the deposit of munitions in federal waters. And so it was a violation for them to do that. And in the case brought by Puerto Rico to enjoin the fleet from doing target practice there at all.
I have to say, just posing that question to enjoin the military from engaging, I think you might have had some weight on your side of the case.
Oh, yes. And I joked that I would like to have a number of admirals with their medals on sitting behind me. But anyway, at some point during the case, Justice Powell asked my opposing counsel, under your theory of the case, if PEPCO were depositing any kind of polluting object into the water, that somebody opposing this should get an injunction that would cause PEPCO to shut down its plant that provided electricity to the entire Washington metropolitan area. And I thought my opposing counsel might find some way to evade that question, but he didn't. He said, oh, yes, that's right. The plant would have to shut down. Injunction, they could get an injunction to shut down the plant. And at that point, I just thought, well, I think we've won this case.
I certainly think teeing up an injunction like that when there might be other remedies, whether it's against the Department of Defense or against PEPCO, would be something that justices would definitely be interested in. Another important aspect of how the Solicitor General's office works involves its interaction with other components of the government, both inside the Department of Justice and outside, including the White House. And you were at the Solicitor General's office at an important time for that. Could you describe how those interactions were developing then and kind of why?
The North Haven. Oh, well, when I joined the office.
Talking more about the relationship with the White House. And I believe that when you were there, Attorney General Griffin Bell, President Carter was now president. Attorney General Griffin Bell was implementing some policies that Attorney General Levi had developed right after Watergate. Could you tell us about that?
Yes. He implemented several policies that regulated communications between the White House and the Department of Justice. And the aim was to keep independence of essential actions of the Department of Justice. And if the White House had questions about a particular case, they were not to call the lawyer directly on the case. They were to call usually the associate attorney general. And if the associate attorney general deemed this something, he might mention something to the Solicitor General's office. He would go over and talk to the Solicitor General, but not to any of the people on the case.
I understand that was a change. There had been, from what I've read, in that era, just in the Watergate era, there was a much freer reign, I think, for White House to call assistants directly.
And these were essentially remedies for the problem that they saw in Watergate. They were trying to divide. So they were popularly referred to as the Levy rules, named after Edward Levy, who was Ford's attorney general, and Griffin Bell. The Congress then passed the Integrity Act, and Griffin Bell then officially promulgated those rules.
Yeah, that's what I had understand. It was really President Ford's Attorney General Levi who developed these rules, and I think went back to this very strong tradition, certainly in all the years that we were there, of the independence of the Solicitor General's office. You also mentioned, I believe, he started the Office of Professional Responsibility.
Professional Integrity, yes, that also was part of the act, yes.
Another thing I was going to mention is you also were at the Solicitor General's office during the Reagan administration. So it was the Carter administration, then the Reagan administration. And the Solicitor General at that time was Solicitor General Rex Lee. And there were some internal dynamics at the Department of Justice between various components about some positions the Solicitor General's office should or should not take. Can you tell us how Solicitor General Lee handled those issues within the Department of Justice in his day?
Yes. Well, the position in that case had been developed under the prior administration. And fact,
this was the North Haven case?
Yes, yes. And there were actually two cases. The government had lost the case in one circuit and won the case in the other circuit. And we had filed for cert in the case we lost, and then we acquiesced in the petition for cert on the opposite side.
Well, this had to do, I mean, I can see the government wanting to acquiesce because the Supreme Court was going to have to resolve this issue. It was an anti-discrimination statute, and it was a regulation of the Department of Education.
Yes. We were basically defending the validity of the regulations that had been developed in the Act. And those regulations had been promulgated during the Ford administration. But the particular regulation involved whether the statute applied to discrimination against teachers when there was no connection to students, and the regulation said yes, it did apply directly to discrimination against teachers without respect to students.
And this all focused on schools that were receiving federal funds.
Yes.
And the federal government was saying, if you receive those funds, you can't discriminate in these programs.
Yes.
And it wasn't just programs involving students, but it involved the employment practices also.
Involving employment. And under the Reagan administration, Terrell Bell, the Secretary of Education, did not agree with that interpretation of the statute. He did not want to be in charge of hiring discrimination cases, and he didn't think it was required by the statute. But in our office, and Rex Lee agreed that there was very, very strong position to argue that it was a valid regulation. If you looked at the legislative history, if you looked at the text, it just seemed clear that this was a valid regulation.
And that it was meant to include employment.
Yes, yes. And we actually had a meeting with Terrell Bell. He came over and talked about his position. And Rex finally said, well, I don't think we can reverse the position in this case about what the statute means. But we put a footnote in the brief.
Footnotes, the last resort.
Yes, exactly. And the footnote said that if the secretary had discretion whether to apply the act as allowing regulating hiring discrimination, he would prefer not to do so. And so it was clear to the court that, all right, we're agreeing what the legislative history says and but this is not a policy position that we would agree with. And I know that Rex often said to us, the credibility of the Office of the Solicitor General is very important. And I think that was what was behind the way he decided to handle this case. He wanted to accommodate the views of the administration, but we had to maintain credibility in how we presented issues to the court.
Solicitor General Lee, as President Reagan's Solicitor General, is very much, I would say, revered for his view of the independence of the Solicitor General's office and guarding that. Another point I'd note is Solicitor General Lee also took it upon himself to argue that case, particularly because I think when the position like that is perhaps going to open up challenging questions about that argument, that he was the one that stood up at the lectern for that.
Yes.
Pretty impressive. Sometimes the special relationship between the Solicitor General's office and the Supreme Court means that lawyers in OSG get interesting assignments that are outside of litigating. You took on a couple of those, I think. Yes.
Well, I was asked by Deputy Solicitor General Larry Wallace. This was during the Carter administration. I should explain first that the Solicitor General is the ex officio chairman of the Supreme Court Bar. And when a justice dies, there's always a memorial in the Supreme Court, and the Solicitor General is expected to coordinate with the court in arranging the memorial ceremony. And this involves making up the list of attendees and sending out the invitations are sent out in the name of the Solicitor General. He's the one.
And it's a limited number.
It is a limited
of
number.
Seats. It's because it's a quite momentous occasion at the court.
Yes. And the ceremony goes in two parts. There's first, and it takes place in the Great Hall. The bar, members of the Supreme Court Bar are meeting to develop a resolution, and that is the focus of it. And a speech is given at that meeting by the Solicitor General. And oddly enough, that speech is written for him by a person designated by the Supreme Court Bar to write the speech. And in the case of the Douglas Memorial, it was former Justice Fortas wrote the speech.
So this is when Justice William O. Douglas had passed away.
Yes.
And there was a speech that the Solicitor General, McCree, at this time, was going to give, and former Justice Abe Fortas Was
wrote
writing it. Well, that's a lot of heavy, impressive people to be dealing with as an assistant.
Yes. And then in the Supreme Court after that, there is a speech that is given by the Attorney General, and I had to write that speech. But you're talking about the important people. I did meet with Justice Fortas and Clark Clifford.
Wow.
And I was told by one of my fellow colleagues, Bill Alsop, had been a clerk for Justice Douglas, but he was leaving the office, so they couldn't ask him to do it. And he told Solicitor General McCree that, well, get Elinor to do it. I think she could handle the big egos involved.
Well, you were naming a couple, I think, significant Supreme Court players. Speaking of very prominent members of the Supreme Court bar, would you share with us that the invitation list situation that arose that you had described with one person that had to be added to the list?
Oh, yes. This was in the case of the Douglas. For some reason, I don't know what I was thinking, but we should have had former Solicitor Generals on the list. And for some reason, Solicitor General Erwin Griswold, known as the Dean, because he had been Dean of Harvard Law School, was left off the list. And when he heard that invitations were out and he had not received one, he called Solicitor General McCree to complain about this. And Solicitor General McCree said, I apologize, this was a mistake by staff.
That anonymous staff out there.
He was very nice that he did not name me.
Solicitor General McCree was also known for his graciousness, I have to say.
Absolutely.
And I mean, the significance of Solicitor General Griswold could not be overstated. He's famously known for being the Solicitor General across not just more than one administration, but I think it's administrations of different political parties.
Well,
I know you recovered because you did another one, but you also went on to handle this for another justice when he passed away, and I think that was Justice Reed?
Yes.
There's another story I heard. I understand after the speeches are given in the Great Hall, there's a reception, and this is several months after the person has passed away, generally.
Yes.
And so, it's not completely somber. There was a reception, and there was a receiving line that you went through.
Yes, there was always a receiving line with the Chief Justices in the receiving line, and usually close family members are also in the receiving line. And I went down the receiving line at the end after most other people had gone through. And this was the Douglas. And Kathy Douglas was standing there next to Justice Berger, and she actually introduced me to, she said, Justice Berger, and she mentioned my name, but I think he didn't hear it. And so he shook my hand and he said, hello, Miss Greenhouse.
I am pretty sure that was a reference to Linda Greenhouse, the incredibly well-respected reporter on the Supreme Court for the New York Times for decades. Did you say anything?
I didn't correct him. I would never want to be in the position of correcting.
Good call.
But I realized afterwards, she and I had dark hair and wore glasses, so.
There you have it. So I am sure when you went on and handled the memorial speech in the role of the Solicitor General for Justice Stanley Reed, that Solicitor General Griswold was probably at the top of the invitation list.
Yes.
I wanted to turn to your career now, Elinor, and it's so rich in government service because you were working on Supreme Court cases before you came to the Solicitor General. So let's start you graduated from George Washington University Law School, I believe. What did you do after that, and then what was your path?
Well, I clerked for a district court judge in the D.C. Circuit, Oliver Gash, and then I went to I joined the National Labor Relations Board after that, and specifically I joined the appellate court branch.
Can you tell us just a little bit, and I know everyone in the government refers to it as the board, what the role of the National Labor Relations Board is? It's not the Department of Labor.
No, it's one of the independent agencies developed in the Roosevelt administration, and they have jurisdiction over private companies' labor relations. There was originally the Wagner Act, which only applied to companies' violations, the rights of unions to organize, and companies' violation of certain rights. Later on, the Taft-Hartley Act was passed in 1948, and that created rights for employers and protected them against illegal boycotts and various other things.
So this is the dynamic between employers and unionized
Yes,
employees.
yes.
And the board adjudicates as an agency,
Yes.
and then they go to the court for judicial review.
Yes, the judicial review is in the courts of appeals.
So you were doing a lot of that work as an
Yes,
appellate
I was
lawyer.
doing. Well, actually, one nice thing about the appellate court branch is we primarily defended the board's orders in the courts of appeals, but we also could be called upon to do what was called special litigation when we'd get sued in district court, and usually we'd just go there and have a motion to dismiss for lack of jurisdiction. And we also occasionally, the Supreme Court, head of our Supreme Court bench, would ask a lawyer in the appellate court branch to write a Supreme Court brief. So that's how that came about.
I mean, the National Labor Relations Board counsel office, I think, had a much more sophisticated appellate practice than other agencies, and Nort Cum was a long-standing, very well-respected head of the Supreme Court practice there. And I first met you along with Nort when he was working with the SG's office on some of the Supreme Court cases. So how did you come from working at the National Labor Relations Board to the Solicitor General's office?
Well, one of my colleagues at the NLRB, Roger Bryce, had been a fellow student with Frank Easterbrook at the University of Chicago Law School.
And Frank Easterbrook was a
deputy. He was a deputy Solicitor General at that point.
Right.
And Roger had had lunch with Frank, and Frank had told him they had an opening in the office. So Roger came back and told me, they have an opening in the Solicitor General's office, and I think you should apply for it, Elinor. This would never have occurred to me to do. But anyway, Roger said, yes, you should apply for it. So I did.
Terrific. And you were there for many years, as we talked about that. I understand that your tenure in the office of the Solicitor General actually went a little longer than you expected.
Well, I was first planning to leave the office and return to the board in September of 1981, and I actually went back to the board, but I took a little time off in between, and I got a call from Larry Wallace, who was a deputy Solicitor General, saying, "Elinor, I have good news and I have bad news. The bad news is that President Reagan has imposed a hiring freeze, and it's a hard hiring freeze. So even though the board has already hired you back and you have a date for returning, they can't hire you back. But the good news is if you agree to have me withdraw your resignation at the Solicitor General's office, we can take you back." So that's what happened. I worked there for another term of the court.
Wonderful. What did the other assistants think when you were gone, but you were back?
Well, one of them, as a little joke, left a note on my desk that said, "Your share of the unsuccessful Stillman retirement luncheon is $8.37.
They wanted to pay you back for the lunch that they had because you were going to be leaving the office. I like that very much.
Yes.
After you were back at the board, you managed to snag another Supreme Court argument. How did that happen?
Well, it was Operating Engineers versus Jones, and it was a preemption case. And I had written the board's brief. It went through all the way through to being printed with nobody making any changes. It was entirely my brief. And the Solicitor General, I will say there was a special relationship between the Solicitor General's office and the board's office.
Yes.
Probably dating back to the time that Charles Fahey was originally the first general counsel of the board, and then he became the Solicitor General at the department. And I think he trusted the offices of the NLRB, so they always got some deference, I can say, that other agencies didn't get. And Larry Wallace once asked me to talk to a person who just joined our office who had a board case, and I was to tell this person, don't do a lot of editing in this. The board knows its business.
I agree with you that there is that special relationship with a couple offices, but particularly the board. I do think it's due to the expertise and the quality that that office had. Decades later, I actually worked on the recess appointments clause cases that had to do with the National Labor Relations Board, and they have different type of litigating authority also in the lower courts.
Yeah.
And they came and asked us to work with them, the Department of Justice, on the constitutional issues. And it was a great partnership because of the quality and this long tradition of that relationship. You were still working at the board when I joined the Solicitor General's office in the 1990s. I remember that.
Yes.
I just want to say you've had such a remarkable government career, and thank you for just sharing these few snippets with us of that inspiring
Well, it
time.
was a wonderful time of my life.
Thank you.
Thank you.
Our guest, Barbara Etkind, joined the Office of the Solicitor General in 1980 and served there through 1984. She was number 5 among women assistants to the Solicitor General. Welcome, Barbara.
Thank you very much.
One of the things that Solicitor General's office is responsible for, of course, is all of the arguments before the Supreme Court. But in addition to the assistants in the office, there are also 4 deputies and the Solicitor General. So assistants often take on the job of briefing cases that they don't argue. But sometimes those are the most significant arguments because the Solicitor General, him or herself, believes that they need to argue that case. Barbara, I know you had a wonderful experience with one of those cases, and could you share that with us?
I will. And Judge McCree, Wade McCree, was the Solicitor General, and he was arguing the case. I knew him from before because I had clerked on the Sixth Circuit a few years after Sarah Beale.
And so was Solicitor General McCree the one that argued a case that you worked on with him? I think it was the Rotzker case?
Yes, he argued it, and I was really honored, and I was honored, and I was thrilled, and I was also sort of intimidated because this was the first merits case I would have dealt with, and it was fairly early in my time at the Solicitor General's office.
And it's a very important legal issue.
It was a very important legal issue. The issue was a class of men who were between the ages of 18 and 26, that it would be draft eligible, sued because they said, and no women were eligible to, required to register.
And this was the register to draft to go into the military.
Yes.
And so the Did the men bring a type of equal protection claim?
Exactly, and it was men who brought that.
That certainly would be the type of case of such magnitude that the Solicitor General himself would argue.
That's right.
So you played the role of preparing the briefs, and then I'm sure you helped Solicitor General McCree prepare for argument.
We had a moot court,
Mm-hmm.
and there was a deputy on the case too, Louis Claiborne, and he was a beloved deputy.
Yes.
And elegantly, he wrote beautifully. At one point when we were drafting, he wrote a sentence, "Much ink has been spent on this issue." He was great. The registration was unconstitutional because it was only for men. The government took a direct appeal to the Supreme Court. In that argument, the court was very active, especially for that time. Probably was as active as it is now.
Which would be unusual, but because back in that day, the kind of the aura of Supreme Court arguments was calmer.
Yes.
Certainly, yes. A lot of questions, but it sounds like this was a more vigorous one.
Every justice had at least one question, and many of them had question after question after question. Even Justice Stewart mentioned, well, we've been interrupting you, so I'm going to do it again.
You were at counsel table with Solicitor
Yes.
General McCree.
Yes.
So there's Solicitor General McCree's at the counsel table, and then you're sitting next to him. Was there a deputy? Was Deputy Claiborne there
Yes,
also?
he was there. He was there. Now, since the case was heard in 1980, over a decade that had been rife with arguments about
Gender discrimination. And then Justice Ginsburg, in fact, argued some of those cases. That was the era she argued a few cases about gender discrimination. And so this case comes up. On the one hand, it's gender discrimination. On the other hand, it's the U.S. military. Now, let's go back to Solicitor General McCree. I'm sure he had answers to all of the questions that the justices asked. How do you think the justices were satisfied, or did you get a sense of where they were going during the argument?
I think they were not. He did a good job.
Of course.
I don't think they were satisfied. They were hot button issues.
Mm-hmm.
And finally, when the court decided, it went 6-3 in favor of the government. And
So it upheld the validity of the male-only draft registration.
right, and it was surprising to me that the district court, all of the parties had arguments about the standard of review. It was a big deal then. But Judge Rehnquist, who wrote the opinion, decided to not touch that issue. All he wanted to talk about was the customary deference we give to the military. And he said it was the deference we give to Congress, and even more so in the military era. And he went on and on. Not only is the scope of Congress's constitutional power in this one area broad, but the lack of competence on the part of the court is marked.
And that was when Justice Rehnquist was justice. He was not yet Chief Justice.
Correct.
But he was given that, assigned the case to write the majority opinion.
Yes. And in that case, Justices Marshall and White dissented, and Brennan joined those dissents. And as of 1981, women were not eligible for combat, either by statutes or policies among all 4 services. But in 2013, the Department of Defense lifted the ban on women being in combat. And if the case had been heard then or after then, it would have been a much easier case for the government because harder case, more difficult case for the government, because the government's case largely turned on the fact that if you register women, you will draft women. But since women are ineligible, the military will have much less flexibility in who they call to the front, who they keep back. But that wasn't going to be true after 1981.
Well, that makes good sense. So, as you were explaining, because women at that time could not go into combat, the government had a stronger argument to say, well, that makes sense, so only men then have to register for the draft. But indeed, women were serving. because they would enlist on their own, even if they weren't subject to the draft. And then ultimately, as you were pointing out, they were eligible to go into combat. And I think that's a very good point. It would have been a harder argument for the government to defending a line in draft registration between those two groups then.
Definitely.
I'd love to hear about your first argument. Also, Barbara, I know that it's always an incredibly momentous day when you make your first argument. And one thing it'd be interesting to hear from you is just kind of how you think it went, and then what do you do after an argument? Obviously, it's a period of exhilaration and exhaustion. At least that's how I felt afterwards, and you certainly need a break at that moment. So could you tell us a little bit about what you did after your first argument?
Okay, well, the argument was the case was United States versus Cortez. And it was involved border patrols stopping a truck at the Mexican border. And it was found by the courts below that was an illegal stop. But when it got to the Supreme Court, I think that the holding was that these Border Patrol officers knew the totality of the evidence. They knew that at what time these trucks usually went past, and several other things. But one of the things was that one of the people who came through frequently from Mexico had shoes that had like a chevron shape on the shoes. Mm-hmm. So that was one of the circumstances. So in fact, the person who drove the truck had that kind of shoe. And I think it was the Chief Justice, I'm not sure, held that the totality of circumstances justified that kind of suit. And that was a pretty new standard. So we went for the government.
So you won the case for the kind of based on the Border Patrol's actions, officers' actions at that search. Of course, you didn't know that right after argument. So you come out of it, you probably found that out a couple months later.
Yeah.
So you come out of argument, and I understand your family was there.
Well, they were. And after the argument, we went to Dominique's, which is no longer there, but it was a lovely French restaurant. And I think a lot of Supreme Court people went over there after arguments. Mm-hmm. It was and while I was there, a young woman came over to me and said that she and her friends, who were also at the restaurant, had been at court in the morning, and they had heard my argument. Mm. And she showed me a schedule of cases, and she told me they were there as guests of Justice Blackmun. And she showed me the schedule of cases that Justice Blackmun had, which was a different schedule than we were given as our advocates. And on it, he had written, "This is her first case." Mm. That was very sweet. A few days later, I got a letter from the woman enclosing this schedule saying that she knew that it had more sentimental value for me than to her, and she felt that I should have it, which was very nice.
And I assume you kept that.
Well, I brought it with me to show you.
Oh, I'd love to see it. I have to say, that would have been an internal scheduling order that the Justice Blackmun signed, and for him to have given that to her and her giving that to you, it's very special.
But the day continued with very special things, because after lunch, we went to Georgetown. My sister was there. She wanted to see what Georgetown was about. We left the car in a parking place that was available until 4:00. But when we went back to the car, it wasn't there. And it wasn't quite 4:00. So there were two people in the empty spot ahead of us. And they came back to us and they said, our car was taken even before yours. So you should come to traffic court with us, because if we win, you win, and we'll speak in your defense. And so they went. My husband went with him. And they won. The citations were thrown out. And when they came back with the two men. And the two men turned out to be Border Patrol officers who had been in the court listening to the argument. It was just amazing, very, very amazing. But it was a wonderful day all around. My husband was very glad to say he won in traffic court that day, and I will win in the Supreme Court that day.
That is a wonderful story. Your second argument at the Supreme Court also stood out a bit from what I understand, and also was apparently specifically appreciated by the court. Could you tell us about that?
Yes. The case involved a very straightforward issue of statutory construction of the Youth Correction Acts. So it was a very easy case. They had all the other cases below had gone the opposite way, which was the government's way. So it was going to be a slam dunk if there going to be that kind of a thing in the Supreme Court. So as I watched counsel for the petitioner argue, at one point I saw the justices' eyes just begin to glaze over. So when I rose to talk, I spoke as briefly as I could, and in order to get to the end where I could say, if the court has no more questions, I'll rely on my brief. We still won 8-0. They 9-0. They didn't really need anything I said, but.
Well, I have to say, reading the court like that is a real gift, real ability to see when you need to speak or if their eyes are already glazing over. It sounds like you made a good judgment to make it short and sweet and then rely on your brief for the rest.
But several months later, someone told me that they heard that Justice Brennan said you had given the best argument he had ever heard. And of course, I knew what he was talking about. And finally, I owned up to the fact that this was not a good argument. I mean, it was a good argument, but it wasn't a difficult argument.
He appreciated the brevity. I'd heard that story too, and I can believe it, particularly back in those days. The court would almost every day hear 4 arguments. These days, the court usually hears 2 in the morning, but in those days, there'd be 2 in the morning and 2 in the afternoon. So it was a very long day for the justices on the bench. I wanted to get a little bit about your career, Barbara, and how it was that you, what you did after law school and then your path to the Solicitor General's office and after that.
Well, as I said, I clerked for the first year. Mm-hmm. And
in the Sixth Circuit? You went to the University of Michigan, I believe?
Yes. Okay. And then I went to, my husband and I moved to Philadelphia for his job. Mm-hmm. And I got a job with a very large firm there. But about 3.5 years into that position, I was very bored. And I recalled Justice McCree, and I knew of the Solicitor General, so I just wrote him a letter. Mm. And shortly thereafter, I was invited for an interview, and I got the position. I like to think it had nothing to do with Justice McCree, but I'm sorry, Solicitor General, but I'm not sure about that. In any case, I got the position, I accepted it, and it was the best move in my career I could ever have.
What led you then eventually, I guess, to go into private practice? You were at a terrific firm for years.
I was. I joined this firm. Back then it was called Ross, Dixon, and Masbeck. I was the 16th person. And I made a point to see all of them. And I joined because of the people. And it was a good decision. Even to this day, I'm very good friends with lawyers and even a couple of non-lawyers from that firm. So I was happy, very happy I did it.
That's a great piece of career advice about looking to the people you're going to be working with and being one of the first 16 lawyers in a firm that's getting in on the ground level. I know you're currently still working. I know you have immigration matters and you're, I believe, counsel emeritus at the firm or senior counsel?
Actually, no. The firm merged several times after I retired. And one of the times was with Pepper, Hamilton, and Sheets, a firm from Philadelphia. They had a very well-known pro bono practice. And part of that was they had a foundation, the Pepper Center for Public Service. And it was for retired lawyers who wanted to continue doing pro bono. So that's what I'm involved in now.
Terrific. Well, you've had an amazing, rewarding legal career, and we're very appreciative for you to have come here today to let us learn a little bit about it. Thank you.
Well, thank you. It's my pleasure very much.
Thanks, Barbara. In 1982, our guest, Carolyn Corwin, joined the office of the Solicitor General to argue Supreme Court cases for the next several years. It was quite an opportune moment because the Supreme Court, had just welcomed its first woman member, Justice O'Connor, who joined the court in 1981. Welcome, Carolyn.
Thank you.
In that time frame, could you give us a little bit of your sense of what it was like to argue before the court, and particularly Justice O'Connor in those days?
I'm happy to, and it was a great honor to argue before the court. It was also quite a pleasure. You're up right close to the justices. It's like a conversation. I did very much enjoy being questioned by Justice O'Connor. It was not always easy. She was very precise, and she asked very good questions, and sometimes they really put you on the spot. I do remember one case I had, I think it was Longshore Harbor Workers Act case, where there had been some legislative activity that was relevant to the case. I found out about it only when I had a moot court with the Department of Labor attorneys, who happened to mention, as they were leaving, that there was something on the Hill. And I said, oh, what? Tell me. Well, the first question I got on that case was Justice O'Connor saying, "Counsel, there's legislation pending on the Hill. Does that affect the outcome of your case?" I was very happy to be able to say no.
Justice O'Connor brought a lot of unusual and unique things to the court. She'd been a state legislator in Arizona, and you really saw that. And I was a law clerk at one point. You could see Justice O'Connor was very interesting in granting cert and reviewing cases involving state legislation. That was a particular interest of hers. And of course, she'd been a state court appellate judge. So that sounds very much like the Justice O'Connor, what she brought to the court in her day. I guess in your day, she sat over at one of the ends of the court.
She was the junior justice. She was right at the end, yes. I will say also that this was a time when the arguments were calmer than they are now. It was before Justice Scalia joined the court, and there was just not as much verbal action as I think there subsequently was.
Well, I certainly have heard that was true. That was true in the time of when I clerked compared to when I was in the Solicitor General's office. But there were still some arguments that could get pretty feisty, I guess.
Yes.
And certainly that experience comes to lawyers in the Solicitor General's office when it's a particularly challenging case. Challenging cases make challenging arguments. Could you share with us one of those experiences you had before the court?
Sure. I would say my first argument was pretty uneventful, but the second argument was a case that I was really not looking forward to because I think we knew that there was going to be a lot of resistance on the court. It was a case involving the National Labor Relations Board. It had held that an employer had violated the labor statute. This is Bill Johnson's Restaurant was the employer, and there wasn't really any doubt. He had sued his employees, and there was really no quarrel about the fact that it was retaliation against the employees' exercise of protected rights.
So he had fired the employees.
I'm not sure. I think he probably had fired them, but he certainly was suing them.
Okay.
For filing unfair labor practice charges, for picketing the business. And the board had said, that's an unfair labor practice. That violates the Fair Labor Standards Act, I believe. And they weren't really too concerned with whether the suit itself was meritorious. And that's really what was bothering the court. The minute I got up, I took a deep breath before I was going to say the traditional opening, "May it please the court." I did not get to say that. Justice White was down my throat the minute I got up and was just after me about how could the board have done such a thing. It was just not appropriate for the board to find that this was a violation if it wasn't clear whether the suit against the employees was well-founded. So after that, each member of the court, I think not Justice Marshall, but every other member of the court in turn railed at me politely, more politely than Justice White, about the board's position. So I did come away feeling pretty battered, but I also came away thinking, wow, if I survive this, I think I can survive anything. So it was an educational experience.
Well, you certainly survived and went on to argue many more cases. You had mentioned about talking to the lawyers at the National Labor Relations Board later. I guess they were not surprised that the government's position lost.
That is true. They were in the moot court, and I think everybody knew it was going to be a real uphill struggle. And I'll tell you, Elinor Stillman, whom you have talked to with this particular program, was at the board by then, back at the board. I came in when she left the office, the OSG. So she was back at the board at the time when I was arguing this Bill Johnson's restaurant case. And she observed to me later that at least her perspective was the board knew they would lose, so they decided to send a sacrificial lamb from the Office of Solicitor General, not to argue with themselves, but to do that.
I can see that was probably a good choice on their part.
Well, I guess I was the sacrificial lamb.
Could you share a little bit about another tough argument you had? It was the Locke case. And, as government lawyers in the Solicitor General's office, there's a very important tradition of defending the constitutionality, the legality, the validity of statutes that Congress passed. It's a very high standard if the Solicitor General's office is not going to defend that. And also to interpret statutes as they long have been interpreted as agencies have, but not all the time. But again, it's a very high threshold. So you had one of those cases that seems to have been a challenging position to take.
Well, it was not a very attractive position, let's say that. The statute required the filing of some sort of paper by a mining permit owner that had to be done before December 31st. That was the statutory language. This particular mining permit owner was a really mom and pop operation, and they had called up the local Bureau of Land Management and said, when should we file? And we're told, by December 31st. So they filed on December 31st, not before. They then, when their mining permit was taken away, they did sue and say the statute's unconstitutional. Somehow it created an unconstitutional presumption that they had abandoned their permit. And besides, by filing on December 31st, that was substantial compliance with before December 31st. It wasn't a very attractive sounding argument, but I was virtually certain we would win, and we did. I don't think I got a unanimous decision, but I did prevail. Justice O'Connor did mention in a concurrence that she thought maybe they would have an estoppel argument on remand. So who knows what happened after that? I don't know.
I think that's an example that the approach to statutory text with plain language is a long-standing. It certainly got much more robust, particularly after Justice Scalia was on the court. But the text of the statute did create challenging or unattractive arguments for government lawyers in some instances. Another aspect of arguing as an assistant that we've talked about before is some of the cases that you argue at the time don't seem that consequential. I mean, they're great significance to the parties and whatever the doctrine is going to be from the Supreme Court for the government going forward. But some of those cases turn out to be cited a lot more than you would expect. I know you had some of those, but the one I wanted to hear about was I believe you had a case that involved the king of rock and roll.
I did. I had a case involving the Interstate Transportation of Stolen Property statute, and it involved bootleg recordings of Elvis Presley. The issue there was whether what was stolen, which was the sounds, copyrighted sounds on the recordings, was sufficient to meet the interstate transportation of stolen property, or whether you had a tangible transportation of goods across the border, state borders. I'm afraid we lost that case at the end, but I had an enjoyable time preparing for and arguing. One of the lawyers in the criminal appellate section who had drafted the brief that came up to the SG's office, which I worked on then, was named Gloria Ferris, and she was incredibly helpful. She was shocked at my lack of knowledge of Elvis Presley's work. And that was perhaps...
Well, you're just admitting everything, aren't
I know.
you, Carolyn?
Perhaps because I'd been out of the country in my growing up years for several years. In any event, she went out and bought me an album of Elvis Presley's greatest hits, so I would be sure I knew what I was talking about. And she also found a colleague of hers from a local faculty, law school faculty, to talk to me about intellectual property issues with this kind of bootleg album. So it was really very nice to have someone in the appellate section being very helpful, really being a great support when I was preparing for the argument.
So that case is often cited for a proposition that really has nothing to do with Elvis.
Right. A few years later, the proposition was we construe statutes narrowly, the criminal statutes narrowly. It's a well-known proposition that shows up in lots of cases, but it never occurred to me that this case would be anything special. But one of my colleagues in private practice after I left the office came up to me and said, "Oh, I saw a case that you argued." And I said, I bet I know the principle you're going to cite. So that's one where I wasn't expecting it, but yes, people know about it.
I also appreciate your recollection about working with the attorney in the appellate section of the criminal division. It's not often known, I think, or understood, but all of the career lawyers at the trial level and the Court of Appeals work with the Solicitor General when their case goes up to the Supreme Court. And they just are so critical to the record they've developed, the arguments they've developed. Once it gets to the Supreme Court, there's got to be a broader lens opened up because it's going to apply across the country and to different agencies and different situations. But that relationship between the assistant to the Solicitor General and the career lawyers in the appellate section is very special.
Yes, and they've always been very helpful in terms of providing a lot of the substance of what we argue. And obviously, as you say, we have different perspectives. We had a broader perspective in the SG's office, but it was incredibly valuable to have the people who were more familiar with the whole subject matter to be helping us.
So we've talked a little bit about being in the Solicitor General's office, and sometimes you'll get an assignment that's not a litigation assignment. Sometimes there's a special relationship with the Supreme Court where the Solicitor General does something with the Attorney General. I understand you were asked to take on a special assignment that wasn't a particular case, and you turned it down.
Well, that is correct. Now, that wasn't a purely legal assignment, but the Solicitor General's office had a softball team, and the softball team was all male. They got a lot of flack from all the other teams in the league about that, and I think the deputies were really rather anxious to get a woman on the team. So I got leaned on quite hard by one of the deputies to join the softball team, which, by the way, had such luminaries as Sam Alito, Carter Phillips. I mean, these were heavy hitter guys. I did not want to show off my lack of softball skills. I thought better to preserve my reputation for good legal work and not sully it with my deficient athletic skills. So I said no.
Well, I think it's admirable that you stuck to your guns. And I often heard about the civil appellate team, particularly giving the Solicitor General's office a hard team. They had a real long-term rivalry, and they did have women on their team.
Mm-hmm.
When you arrived in the Solicitor General, you already had a background in business laws and antitrust. How did that play out in case assignments in the office?
Well, I will say that just from a general perspective, I'm kind of a dilettante. I really do like lots of different subjects, but I had particularly enjoyed in private practice antitrust cases and other financially oriented cases. In the Solicitor General's office, I had hoped to get some of those cases, and for the first year or year and a half, I really did not. And I made a point of speaking up at one point to the Solicitor General, to Rex Lee, who was really quite a wonderful person. And I said, I'd really like to have these cases that are more consistent with the interests that I've had for a long time and that maybe I would go back to someday. So I lobbied for some antitrust cases and for more business-oriented cases. I continued to get a whole range of cases, which was great, but eventually I did begin to get some antitrust cases in particular and enjoyed those quite a bit.
Wonderful. You also, I think, wanted to work with some particular deputies. There are 4 deputies in the office in addition to the Solicitor General, and the 4 deputies, one of them is on each case and works with you. They're divided by subject area. So sometimes the subject area you work with drives the deputy that you're going to work with.
Yes, well, that's true. And I had worked a lot with, there were really 4 deputies, well, maybe 5, but I had worked a lot with 3 of them and then began to work with another one. But there was a 5th deputy, Louis Claiborne, who was someone that I really did want to work with. I wanted to work with all of them. He, I think, tended to work a lot with people from the Lands Division. And he had people that he went to, but I had not been one of the people that he worked with on a merits brief. So I lobbied for that as well and ended up with several cases with Louis.
Wonderful. When you were in the office, Carolyn, that the number of women eventually reached 4, and that was a record at the time. Just wanted to take a moment. I think it's important to note here that that number of 4, when you were in the office, did not occur again until I was in the office. After Solicitor General Days started wondering why there was such a narrow pool of applicants that he received. Solicitor General Days had also been head of the Civil Rights Division before, so he was well aware of the broad, highly qualified pool of attorneys out there. And he was concerned about the narrowness of the pool that was given to him for hiring. So he asked me to look at kind of the process. And so Solicitor General Days ended up implementing 3 changes. He required a broader public posting of the openings so that potential applicants could see them. He also eliminated any initial screening within the office of applicants based on law schools. And he also then required that during the interview process that each interview have 2 current members of the Solicitor General together. And that had a direct result. That's what meant that within, I think, 2 years of that, we were back up to 4 women assistants in the office. I do think that process can drive substance, one of my themes. So the other kind of facet of your career we wanted to talk to you about kind of what you did before the Solicitor Generals and what happened afterwards. So when you got out of law school, well, where were you in law school?
I was at Yale Law School, your alma mater.
Yes, and I thought so because you were there in the very early days of a significant number of women in the law school. There had been women at Yale Law School pretty early on, but really your time was when they started admitting a significant number. So what did you do then?
Well, I will say you're right that I think I came into the legal profession about the time that things were changing so that it began to feel as though there was a critical mass of women, that we weren't totally alone anymore. And that was true in law school. but still in private practice, it was evolving. So when I got out of law school, I did a district court clerkship, and then I had always thought I would be a long-term government lawyer. I had had some federal government jobs before law school and had gotten to know lawyers in the federal government, and I thought, well, this is really where I'll end up. But when I got out of law school and clerkship, I didn't know for sure what federal agency I would want to start in. I had done a summer associate position at Covington and Burling in D.C., and I decided, well, I think I'll go to Covington for a few years. I know there are lawyers there who have left for the federal government and returned. So I thought that Covington would be receptive to someone who might eventually go into federal government and wouldn't be annoyed when I did. But I began to enjoy private practice quite a bit more than I'd expected. I did stay, though, for 4 years, and then one of the people I had worked with when I first came to the firm, who had left for the SG's office and returned, stopped me one day and said, "Why don't you put in an application at the SG's office?" And I thought, well, that will never lead anywhere, but I'll go ahead and do it. And it did lead to a job, a position. So I was very happy at the Solicitor General's office. It was a great honor, as I said. I really enjoyed what I did, a whole variety of cases. But I began to think long term, I missed the things that I had done in private practice. I really enjoyed working on things at the trial level where you got to work with expert witnesses, with clients who could tell me how to run their business. And it was just something that I thought I would probably thrive in more long term than doing all appellate work. And I did, therefore, return to Covington. But the practices I had after that, and again, I continued to do all sorts of different things, but it was largely trial level work as I had wanted, but also appellate work would come my way just because of the experience I'd had in the Solicitor General's office. So I would say I've had a combination of continuing with antitrust litigation and then getting into some other areas, even doing a little advisory work for a while. So, and I would say I had a number of appellate matters over time in private practice as well. So that was a continuation of what I'd done in the SG's office.
I had the pleasure of joining you at Covington and Burling after some of my government service, and I think that's such an accurate description of the office. People do come and go from the federal government in the best sense of it, in the greatest tradition of public service. I enjoyed working with you there, and I know to this day, I believe you're senior counsel there, still held in a very high regard, and also very well known for mentoring more junior attorneys at the firm. So,
in fact, I am right now supervising an amicus brief for a Supreme Court case, supervising 3 junior lawyers. So
wonderful.
That's right.
Wonderful. Thank you so much for joining us today,
Thank you,
Carolyn.
Beth.
Our guest, Kay Oberly, joined the office of the Solicitor General in 1982 and served there until 1986. Kay, your career included arguing in the Supreme Court both before you were in the office of the Solicitor General and after you were in the office of the Solicitor General. How did your first Supreme Court argument come about? I understand you were in the Lands Division now of the Department of Justice at that time. It's now called the Environment Division, but you were a Lands Division attorney, but you got a Supreme Court argument. How did that happen?
It was the outgrowth of a Lands Division argument where the United States was defending against an action by the state of Alaska that was intended to stop President Carter and then Secretary Cecil Andrus from designating 56 million acres of land of public lands in Alaska as a national monument. It wasn't just a little statue or river, it was 56 million acres they were trying to protect because of slow congressional action. And I was there in Anchorage, flown from Washington, because we feared that the government might be enjoined and we would want to go immediately to the Ninth Circuit and get a stay pending appeal. And as the land's appellate lawyer, we wouldn't have time to wait for a transcript. So the idea was if I was there in Anchorage, I could go immediately to San Francisco without having to wait for a transcript and get appellate review. So our trial lawyer, who was totally on top of the case, well prepared, but we were all exhausted and dehydrated and from the work in getting ready for the trial court hearing and getting ourselves to Alaska. He stood up to argue and he said, "May it please the court?" And then he just stopped talking. I could not see him because I was sitting at counsel table behind him, but the judge could see him and saw that something was wrong. And so the judge immediately called for medics to come into the courtroom. And our lawyer was fine but later in the afternoon, but at that point he was just dehydrated and exhausted. And so they took him to the local hospital to check him out. And at that point the judge said, "Does the United States have anybody else here who can argue this case?" Because it was being dealt with as an emergency for legislative deadline reasons. And I thought, the reason I'm here is to go argue this case in the Ninth Circuit in case we lose. So I felt like I had to answer the judge's question that yes, I could argue the case. The judge said, "Okay, we'll take a short break, and after lunch we'll come back and we'll hear from you on behalf of the United States." This is in the trial court. It's not in the Supreme Court at this stage. But the argument went well. And it's the day before Thanksgiving. So the judge said after the hearing that he was going to take Thanksgiving Day to think about the case, but he would have us all back in court in Anchorage on Friday morning and tell us his ruling. Now, I reported back to Washington that I thought things had gone really quite well, and I did not believe we would be enjoined, and that I did not have to leave Anchorage and fly to San Francisco looking for 3 Ninth Circuit judges on Thanksgiving Day. So fortunately, on Friday morning, we did get a ruling in our favor. The state of Alaska's injunction motion was denied, and all was well for designating 56 million acres of Alaska public interest lands before Congress had a chance to pass legislation it was working on. Come back to Washington, and Jim Mormon, Assistant Attorney General there at that time, wanted to do something to thank me for arguing the case in the district court and for how it had turned out. So there was a practice then. I don't know that it's still observed, but there was a practice when the Supreme Court had 150 or so cases a year, that they could afford to give at least one argument a term to the Assistant Attorney General of each division if they happened to have a case coming up that term from out of their division. And Jim did have a Lands Division case coming up. He called me at home. I was home on maternity leave the summer of 1979 and said, "Would you like to argue a case in the Supreme Court?" That was my reward for how things had gone in Alaska. And I said, "Of course, I'd be thrilled." And so I am assuming that Jim has some authority to tell me that he'd like me to be able to argue this case. And the problem was that he then told, after the fact, he told the Solicitor General's office that he was going to have me argue his case, his allotment, instead of himself. And he was told politely, but told firmly, "It's not your case to give away." That we in the SG's office are, we argue the cases for the United States, but we do let an assistant AG argue a case, but it's not for the assistant AG to give it to someone else to argue. So Jim somehow worked it out with the SG's office and said it was important to him, and not to mention the fact that he'd already told me that I could argue this case. So it was worked out by agreement with the SG's office that I would argue a case called Kaiser Aetna versus United States, which the court had granted cert by that time. And I had also argued that case in the Ninth Circuit and won it in the Ninth Circuit. So it was logical. It wasn't a brand new case to me, but no one in the SG's office thought we had any real chance of winning that case. And it involved Hawaiian land and water rights there was a television show at the time called Hawaii 5-0. This case was fondly referred to in the SG's office as Hawaii 9-0, with the expectation that we were going to lose this case 9-0. And so it was, okay, if Jim Mormon wants to give the argument away, we'll let him do it this time, because he's giving away a loser anyway, and nobody in the SG's office was clamoring to argue the case. So I was, in fact, allowed to argue that case while I was still a Lands Division appellate lawyer, and I was home on maternity leave that summer, and so I took my newborn son downtown to justice and got somebody to copy almost every Commerce Clause case the court had ever written, and I spent my maternity leave at home that summer taking care of a newborn and reading Commerce Clause cases in between. Got to argue my first case, as you said, before I had joined the SG's office in 1979. And
Wow.
that was the beginning of my Supreme Court career, although it had a little interlude where I went back to the Lands Division before I was able to return to the SG's office.
Well, how did that come about? I understand that your argument certainly oppressed the folks in the Solicitor General's office, including the Solicitor General himself, Rex Lee, at the time.
Rex Lee was obviously one of my favorite SGs. He was the SG at the time they had a vacancy. There was a gap of a couple of years between the case I argued while in the Lands Division and the time when there was a vacancy in the office. But thanks to my not embarrassing the United States in arguing Kaiser Aetna, which we didn't lose 9-0, we only lost it 6-3, and the fact that I got 3 votes was viewed as having been a credible argument. And so Rex when he had a vacancy in the office, I was invited to apply for it, and I think I got that position because of the argument in Kaiser Aetna versus the U.S. that I'd done in 1979. I'm not sure I would have been hired otherwise, but it worked out to be a wonderful opportunity.
Well, that is a wonderful story about how you came to the Solicitor General's office. I also just wanted to highlight the fact that you were on maternity leave when you prepared for that argument, because these early trailblazing women in the Solicitor General's also opened the path for others. I know Barbara Etkind argued pregnant when she was in the office. And by the time I was in the office, I argued 2 of my cases pregnant. And during the 8 years I was there, from 1993 to 2001, there were more than 10 cases argued by women assistants to the Solicitor General who were pregnant, and that accounted for 5 at least women who did. So that also started a good tradition of being able to, I always hesitate to say the word balance, but juggle all of those things in life. Once you got to the Solicitor General's office, one of the assignments you had there involved the waters of the United States, I believe under the Clean Water Act, and there was a claim of unconstitutional taking the Riverside Bayview homes. That also involved quite an excursion. Could you tell us a little bit about that case?
It did. It was whether what you might just call a small pond or a wetland could be considered navigable waters of the United States, and therefore requiring permitting by the Corps of Engineers before the landowners could develop it or really do anything with it. And it was EPA's position, our client agency's position, that because those wetlands connected to larger waters, that the wetlands themselves were waters of the United States. And the landowners challenged I said EPA, but it also was the Corps of Engineers as one of the agencies involved. There was a challenge to whether that was the wetlands really could be prohibited from development, or whether they just were not sufficiently connected or large enough to be considered waters of the United States. The Corps of Engineers thought it was really important that I see these wetlands before I argued the case. And as you know from your time in the office, by the time a case would get to the Solicitor General's office in the Supreme Court, the facts had already been developed in the trial court and gone over again in the Court of Appeals. So field trips were not something we did to go gather evidence or learn new things about the case. But the Corps of Engineers was just really adamant that I needed to see the wetlands, and we tried to accommodate our client agencies in the SG's office. So they arranged a trip for me to Michigan, where the land and water was located, to view the wetlands. They didn't tell me that we were going in a helicopter because I would get the best visual view then. They also didn't tell me that the helicopter had no closed sides. It was completely, there were seat belts, but that's it. You sat on the side of the helicopter looking out, supposedly down and over to see the wetlands. And I did not want to tell the Corps of Engineers that I didn't think I was benefiting too much from seeing these wetlands, because I was just waiting for us to safely land in this helicopter. I have never before or since ridden in an open helicopter, but it was quite an experience. The Corps felt that it was really important, so we did it. But when I was arguing the case, it actually came, I won't say that it made a difference in the outcome. The United States did win the case, and we probably would have won the case if I hadn't seen the wetlands. But it intrigued Justice Rehnquist, not that he didn't know about the helicopter trip, but he was intrigued by maps and by the physical layout of the wetlands and their connection to larger navigable waters of the United States. And I think because I'd actually seen the wetlands, we were able to have a fun back and forth at the argument with Justice Rehnquist asking me questions about the visual aids. And so maybe there was a benefit to that field trip, but I don't need to ride in another open-sided helicopter.
The things they don't tell you ahead of time. The part of your career that is so historically interesting also, I think, is your longevity at the Department of Justice. So you were in the Lands Division for 8 years, I believe, and then the Solicitor General's office. So you really saw firsthand something we've been talking about, the relationship of the Solicitor General to the Supreme Court, and also the relationship of the Solicitor General to the Attorney General, to the White House, and how the government, comes together to have policies and represent its views. One thing we talked a little bit about before with Elinor Stillman was the Levi rules, about the independent nature of the Department of Justice and how important that was. It was post-Watergate era. He was President Ford's Attorney General and trying to put out some guardrails and policies about that. When you were in the Lands Attorney, I understand you actually had a role in a bit of that.
I did. I came to Washington from my Court of Appeals clerkship on the Eighth Circuit, but I arrived in Washington the day that Nixon resigned. And so the transition of how to regain trust and confidence in the Justice Department and in the government at large and the executive branch was, top of mind for me as a new lawyer just joining the Justice Department and for most of Washington at that time. So when Ed Levy was appointed as Attorney General to become the post-John Mitchell era and change the Department of Justice's reputation and bring it back to what it had been before the Midnight Massacre and other things that occurred during the end of the Nixon period, one of the first things he did was call together a group of lawyers from throughout the department who were all relatively young. They weren't the heads. I'm sure he met with all of the appointees within the department, but he also called together a group of young lawyers who were just honors program lawyers from various divisions and offices, and had us for a brown bag lunch. It wasn't in the Attorney General's conference room, it was just in some informal room. But he wanted to get a sense of what did we, coming in relatively new to the department, think needed to be done. How could we help, or how could all of us together working with him restore the credibility of the department? And so the rules of, wait a minute, it's an executive department, but it is still important that it maintain its independence from the White House. And so the Levi rules, as they were then called now, I don't know if they have a name, but I don't think they still bear his name, but it certainly had become well accepted practice that you didn't just call or have contact with the White House about a case. If contact of some sort was required, just for timing reasons or anything else, you dealt with the White House counsel's office, and that was done at a very high level. And it wasn't that common. I mean, it didn't happen that often. But I think that lunch that Edward Levy did when he first came was a really important step toward moving the department in a new direction after the Nixon era. And I was really honored to be able to be invited to that lunch as a young new lawyer in the department. And it alleviated my concerns, which, having, as I said, arrived in Washington the day that Nixon resigned, I'm thinking, I'm not sure that the Justice Department is really where I want to be. But he did a lot to make all of us feel that our public service was really appreciated and restored to what it should be.
That reinforces the critical role of career lawyers also, particularly the honors attorney program at the Department of Justice. Those attorneys are hired on a nonpartisan basis. Oftentimes you can work in the Department of Justice for decades back then and not know what someone's political affiliation was. And really, the Attorney General reestablishing that, I think it's a great example of humility, driving strong leadership, particularly with them talking to the most junior attorneys as part of that. Thank you for giving us that insight. I wanted to now move on to your career trajectory a bit. We heard about you were clerking, you were in the lands division for several years. But one part of the story actually comes before Solicitor General Lee reached out and invited you to come to the office. You had hoped to go to the office at an earlier point, I believe.
I did. It was even before the Kaiser Aetna case that I argued as a lands division attorney. I had worked with then Deputy Solicitor General Ray Randolph, who then later became a D.C. Circuit judge. I think he's still a senior judge on the D.C. Circuit. But in any event, I had worked as the division attorney with him on a Clean Air Act case that he argued, but I worked with him on the brief and helping him prepare for the argument. And he was very complimentary of my assistance and work on the brief. And he wasn't saying I would be hired, but he suggested I might want to think about applying to the SG's office. And I thought I would actually like to work there. So I did. I'm not sure how you filled out an application. I don't really recall, but I know I made my interest known. And I was scheduled for an interview. The first person who conducted the interview in the office was Frank Easterbrook, so it was a terrifying experience at the time. And
Frank Easterbrook, now still on the Seventh Circuit Court of Appeals. I believe President Reagan put him on the court, but he was a Deputy Solicitor General.
But he was a deputy. So the interview was with several people in the office, and Frank, I definitely remember, was one of them. Then I was escorted from Frank Easterbrook's office down the hall to the then Solicitor General, who was Judge Bork, or just Robert Bork at the time. He wasn't yet a judge, but Judge Bork's office as Solicitor General for the last stage of my interview. And his executive assistant ushered me into the office and showed me toward an open chair and sort of pointed there, like I should just sit there. Judge Bork was sitting in his chair, not at his desk, but just in front of his desk. Didn't say anything. I'm not sure he even said hello. So I sit down, and he's working on the New York Times crossword puzzle. I could see from the paper in his lap that he was working on the puzzle. So I thought, well, I'm not going to interrupt his work on the puzzle. I'm not going to say anything until he does. And he completed the puzzle. It probably pretty fast time. It wouldn't take him very long. Finished the puzzle, and he looked up at me, and he said, the first thing he said was, "Why did you go to the University of Wisconsin?" And That was not a question I expected or had prepared for, but I just said I was a Wisconsin resident and I had in-state tuition at $300 a semester, and that seemed like a good enough reason to me to go to the University of Wisconsin. And I'm still very glad that I did. But then Bork turned to other aspects of the interview, and I don't remember what else we talked about, but interview concluded, and I was in some way or another informed that I hadn't been hired. There was, in my view, a prejudice in the office that favored graduates of named recognized law schools, Yale, Princeton, Harvard, maybe Columbia, but anything else was not a school, that the office hired from during that period of time. The office obviously didn't hire very many women either, because at the time I was interviewing, there were three. It was Harriet Shapiro and trying to remember who else was there when I was interviewing, but there weren't very many. So shortage of women, shortage of schools outside of top Ivy League law schools, and it was not an easy time to get hired in the office. And I think, as we talked about earlier, it was only because of my good fortune in arguing the Kaiser Aetna case later that Rex Lee hired me after that, even though Judge Bork thought my school was not the right school for the office.
I mentioned earlier.
One other thing, when I was in the Lands Division at the time, and the office very rarely hired lawyers from the divisions, or from U.S. attorneys' offices for that matter. The lawyers that they hired were usually men who'd gone to top name law schools and who'd had several years of either working at a major law firm or in some way or another clerkship on their resume before they would be considered even to be hired. But hiring from the divisions, regardless of the division lawyer's background, was just something that the office very rarely did. And I know that changed not only with me, but with subsequent lawyers who came from divisions, and I think, and women and different schools, and made the SG's office a more diverse place with everybody sharing in their backgrounds, handling the cases.
I mentioned earlier that when Drew Days was Solicitor General, he changed very specific parts of the process because of those issues, and it did almost immediately result in definitely a broader pool of applicants. And then when you were there, the high point for women was 4 women assistants when you were there, and we got back to that number by that. He first required more public postings, so there was a bigger applicant pool of people seeking to apply. The second thing was he specifically eliminated any screening of applications by law school. When he first got the applicant pool, he asked me to look into it because he didn't understand why the pool was so narrow. He, of course, had run the Civil Rights Division and was well aware of the much broader pool of highly qualified lawyers. And then the third one, he changed the interview process so people interviewed in pairs. And as you pointed out, he also hired people directly from the divisions. In fact, Malcolm Stewart, who's now a deputy who's been there ever since, was hired from the civil division. So I agree those process issues could really help change that pool and then have a direct result.
But it took, they were terrific, but it took a long time to actually bear fruit, I would say, because when I was in the office, the maximum number of women we had was 4, when it was Harriet, me, Carolyn, Corwin, and Barbara Etkind. I know you've talked to those, well, not to Harriet, but talked to the other 3 and talked about Harriet's important beginning contribution to the office. But I left in 1986, and I think it was a long time before you went from 4 up to 9 and growing. I also remember when Barbara Etkind left that we were down to 3. It was Harriet, Carolyn, and me, and we stayed at 3 for quite a while before it even went up to 4.
By the time I joined in 1993, it was down to one woman arguing. And that's what made Drew, Solicitor General Days, come to me. He hired me as the second woman then, knowing we needed to get those numbers back up and trying to figure, well, not just that, but a broader pool more generally in lots of ways, broader schools. And that's what he asked me to do. So he looked into it. So that was about 1994, 95 when those process changes were implemented. And then, we immediately started hiring from that broader pool, had stellar applicants. I mean, 2 of the 4 or 5 women we hired then are now in the DC Circuit Court of Appeals. So it really bore fruit then. So not only was your arrival at the Solicitor General of particular interest, but your departure also
Yes.
really played, I would say, a significant role in the development of the private Supreme Court bar. At that time, there wasn't this specialized practices that all of the major law firms of people who handled cases in the Supreme Court. To my knowledge, there was basically one very small effort in that regard, but significant, of course. It was former Solicitor General Rex Lee at Sidley and Austin and a former assistant named Carter Phillips. So Carter Phillips, I have to say, is now the president of the Supreme Court Historical Society, still practicing at Sidley and Austin, and I believe has argued 82 Supreme Court cases, the most of any one in private practice. But it was really Solicitor General Lee and
Right.
Carter Phillips at that point. But you decided to change that. Can you share with us that adventure?
During my time in the office, my 4 years, I worked closely, obviously, with all of the deputies, but in particular with Andy Fry, who was the criminal deputy at the time, and with Ken Geller, the civil deputy. I had a lot of cases with both Ken and Andy, and their offices were side by side. And so if we weren't editing or writing, drafting, or whatever, we were visiting in either Andy's office or Ken's office. And came a time when all 3 of us, for unconnected reasons, each one personal situation, but we all had decided that maybe it was time for us to leave the office, just move on to a different phase of our legal careers. And this was a Saturday, actually, that we were chatting. I think we were in my office instead of Andy's, but we were chatting about maybe it was time for each one of us to leave for our own personal reasons, but that it would be more effective if we, rather than any one of us going to a law firm, as Carter Phillips had gone to Sidley, which is a great firm, and Carter's been a terrific lawyer with a great Supreme Court practice. But we thought, if we went as a group of 3 to a major law firm, we would make a splash, at least for a short period of time, with the law firm being able to, whatever law firm it was, being able to announce that it now had an instantaneous overnight appellate practice that did not exist at any other firm. A firm might have an appellate lawyer, but it didn't have an appellate practice group that handled Supreme Court litigation and other appellate matters. So the 3 of us on a Saturday thought, maybe we should do this, or at least give it a try, because it would just be more interesting and better for the law firm if we went as a group. And we called, on that Saturday, we called Steve Shapiro, who had been a deputy in the SG's office, and he was back at his hometown firm in Chicago of Mayor Brown. And Steve thought this was a fabulous idea. He said, "Why don't you all come out on Monday?" And Ken and I said, "Well, wait a second, we're both preparing for arguments the next week, so we didn't think we could go quite that soon." But also we said, if the 3 of us left the office all on the same day, if we were all absent, given that none of us was ever out sick, if all 3 of us somehow disappeared on a weekday, it would be a little, somehow it would be noticed. So and Ken and I said, we've got to prepare for our arguments this week anyway. So we had a case that Ken argued, and which was called Little Bird in the Snow, and a case about Indian practices related to childbirth. And I had a case called Goldman versus Weinberger about a Jewish Air Force chaplain being allowed to wear his yarmulke while in service. And so we both had these interesting cases to argue that week, but we said we could come out the next week, but we ought to come on a Saturday when our absence, although we were usually there working every Saturday, but our absence would be less noticed if the three of us went on a Saturday than a weekday. So all three of us the following Saturday flew to Chicago, met with the management of what was then Mayer Brown and Platt, now just Mayer Brown, and talked through the idea of an appellate practice that instantly would be large enough. The three of us were, more than any one lawyer coming alone, that the three of us could immediately be an appellate practice group that would be something, as you said, that other firms didn't have at the time. And to its credit, Mayer Brown management then, several decades ago, thought this was an intriguing idea, that they liked the idea, and they thought worst case, if it didn't succeed, they would have hired three able lawyers and they would find some way to put us to use. But they liked the idea of starting the appellate practice instantaneous instead of slow growth. So we got a fair amount of publicity at the time, and the practice took off and grew. And other firms, as you know, have replicated that approach. And I don't think there's a big law firm in the country that doesn't now have an appellate practice group. But they're really, even Sidley and Austin with Carter there, I think that Rex Lee left and went back to Brigham Young, where he was president of first the law school and then dean of the law school and then president of BYU. So Carter's remained at Sidley and been a great lawyer, but it wasn't quite the same as our splash into appellate practice in 1986.
I just think it shows incredible business acumen also. And you're right, I ended up in and out of the government. I ended up leading Supreme Court practices at two different law firms that followed in those footsteps. The interesting part of this too, after you're at Mayer Brown, you got to argue another Supreme Court case. And to say that, I mean, there weren't that many Supreme Court cases to be had, and it certainly must have been different than being in the Solicitor General's office, where you, of course, just regularly got assigned a Supreme Court argument. In private practice, it's very different. There are so many law firms out there, and particularly before specialized practices, a wide range of people arguing in the Supreme Court. So can you tell us how you got that argument?
It doesn't happen often, but in the case was Pricewaterhouse versus Hopkins, and another firm had handled the case in the trial court and through the Court of Appeals and had lost the case. So Pricewaterhouse decided to change law firms and go to the Supreme Court practice that we'd created at Mayer Brown. Something came up, a personal matter with the lawyer who had been hired at Mayer Brown to initially be the primary lawyer on the case and to argue it. But I had been working with that lawyer I was a partner, but I was the junior lawyer on the case, helping to write the brief and helping the senior partner prepare for the argument. And something came up unexpectedly where I got very short notice, about 2 weeks, that I would have to argue the case. I would have the privilege from my perspective, but the client hadn't hired me to argue the case. They just were fine that I was along as the junior partner doing the briefing and helping them get ready for the case. But it wasn't they'd hired somebody else. And what's significant to me has been an assumption for all these decades, because the case was a sex discrimination case brought by a female employee of Pricewaterhouse who didn't make partner and alleged it was because she was a female. And so it's been assumed by the outside world that Pricewaterhouse hired me to argue the case because I was a female lawyer. But when in fact they actually had hired somebody else and I was just the helper lawyer on that case. But on relatively short notice, very short notice, about 2 weeks before the argument, I learned that I would be arguing it. And that I would have the responsibility of telling the client, general counsel of Pricewaterhouse, that he didn't have much time to to hire another lawyer to argue that case because it was coming up so soon. The argument date had already been set. So I am sitting in my office in Washington, and he's in his office in New York, and I call the general counsel of Pricewaterhouse, and I just wasn't sure how do I begin this conversation to basically tell him that I was going to be arguing this case for his firm, and they didn't really have time to find another lawyer. So he paused, and then he said, "Have you done this before?" I think he should have known that, we'd met several times during the course of the briefing, but his first question was, "Have you done this before?" And I said, "Yes, actually, I did it, I think, 11 times while I was in the Solicitor General's office." And there's a pause on his end of the phone, and I'm thinking, 11's not bad. I don't know what else I can say. Then he comes back with another question, and he said, "What's your win-loss record? 11 cases." And I said, 10-1. And there's another pause. He's silent on his end of the phone. And I'm now thinking, do I have to explain Hawaii 9-0, as we called it? Do I have to explain that was a case I was supposed to lose, but the other cases I had won? And I have no idea what he's thinking. So he comes back on the phone and says, okay, he has to agree at that point because there really was not time for him to find another lawyer who was familiar enough with the case and had Supreme Court experience to argue the case. So he agreed that it was fine with Pricewaterhouse that I would argue it, which I did. We got a remand, so we got something out of it, although ultimately the substance of the case probably went again in favor of the employee whose name was Ann Hopkins. So the more interesting part than my arguing it on short notice and having to tell the client was my later finding out that these silences in the phone call I had with Eldon Olson, the general counsel, when he first asked, had I done this before? And I said, yes. He asks me how many times. He's sitting at his end of the phone in New York thinking, 11 cases, that is quite a lot. Whereas I'm thinking, how do I explain that I haven't argued any more than 11 cases at this point? And then when he asks my win-loss record, and I tell him it's 10-1, and there's silence again, he's thinking, that's not bad, I'll take that. And I'm thinking, how do I explain the one case that I lost? And so we chuckled about it after the argument was over, about how he was interpreting that phone conversation and the pauses, and how I was terrified that not terrified, but not certain how to make him understand that the argument would be okay. Everything would go as best it could, given the circumstances of changing counsel. So that was the pre-argument stage. Then afterwards, a couple of years later, there was a totally unexpected event. After the case was over, I was standing on the street corner at 20th and Pennsylvania, which is where Mayor Brown's offices were at the time, trying to hail a taxi. There weren't Ubers, there weren't car services, there were just taxis. So I was trying to get a taxi on the corner of 20th and Penn to go to the airport. And an SUV pulls up and stops where I'm hailing a taxi and asks if I want to ride. And it's a woman driving the SUV, and I wasn't sure who it was, but I said, sure, if you're headed toward the airport, I'll take a ride. So I get in this SUV. It turns out it's none other than Ann Hopkins, the respondent, the petitioner, actually, in the case. And she recognized me because she'd been at the argument and, of course, had seen me argue the case. I had no reason to recognize her because I wasn't involved in the trial level proceedings where she was in the courtroom at counsel table and testifying. So when she told me her name after I got in her car, we had a really pleasant conversation on our way to the airport, and it was much better than any taxi ride. It was actually a lot of fun. So.
That's wonderful. What a coincidence, I have to say. The trajectory of your career just continued in this way that you're just interwoven with the Supreme Court after Mayor Brown. You then went in-house, and you can tell us about that. And as an in-house lawyer, which is very extraordinary, you argued a case in the Supreme
Right.
Court.
Well, after representing Pricewaterhouse in a case that had nothing to do with accounting, I don't have an accounting background. So, I mean, Pricewaterhouse was a Title VII case. And then I got to know through that case, I got to know the general counsel of the other then Big Eight firms. It's now Big Four, but I knew the Big Eight general counsel, and I actually handled various matters for 7 of the 8 while I was at Mayor Brown. Ernst & Young persuaded me to come join the firm in their in-house legal department, and as did Pricewaterhouse. I went with Ernst & Young because they weren't requiring me to move to New York. I could still live in Washington as long as I was willing to be in New York as often as needed. So I traveled a lot back and forth on what was then the Eastern Airlines shuttle, I think. It wasn't yet the Delta shuttle, but a lot of back and forth. And Ernst & Young found itself as the respondent in a case where the Supreme Court granted cert. Of course, the normal thing that any private company or firm would do in those circumstances is go hire one of these new appellate practices to handle their Supreme Court matter. And I thought, we don't really need to do that, even though, as we talked about earlier, I had helped, I think, develop the concept of appellate practice groups in law firms. Sitting in-house at Ernst & Young, I talked to the then general counsel, which my predecessor in that role, about the fact that this is what I used to do for a living. I argued Supreme Court cases. So why should we go out and hire a law firm to do it? Because we could save a lot of money if we just did it in-house like we did other litigation in-house. And he agreed, and the chairman of the firm agreed. So the case was called Reeves versus Ernst & Young. And I argued that case, as I don't think very many in-house counsel get the opportunity to argue a Supreme Court case. But since that's what I had done before I went to Ernst & Young, the firm agreed with it, and we did win the case. And what I remember was not only the fun of arguing it from my in-house counsel position, but also I took my then 7th grade son to the argument because I thought, this may not happen again. This could be my last Supreme Court argument. It wasn't really what I was doing for a living anymore. And I hadn't taken him to prior arguments, but I thought, it's this one or none. So I took him, the 7th grader, took him out of school for the morning and had him watch the argument. And then we went back and had lunch at his school at the 7th grade table. And the headmaster asked him to recount his morning and talk about how he didn't enjoy watching his mother argue at the Supreme Court. And the headmaster asked what he thought of the various justices. My son responded that his favorite was Justice O'Connor because he thought she seemed the smartest of all 9. She was the smartest. And he wasn't so fond of Justice Scalia because he felt that Justice Scalia had asked his mother really difficult questions. He didn't say it as really difficult. He just thought that Justice Scalia had interjected more questions for his mother in a different way, which is Scalia style. So it was a good last Supreme Court argument to have, to be in the unusual position of in-house counsel, but also to take my 7th grader along.
That's a wonderful after-argument lunch story. Those after-argument lunches really have a whole life of themselves, and the one going to school I particularly enjoy. After this impressive array of positions as an appellate litigator, it was a good call for you to have your son go to that argument, because you then moved from being a litigator to the other side of the bench and became a judge. How was that? How was your judicial service?
I really enjoyed it. But the reason it came about was I was then general counsel of Ernst & Young, and Ernst & Young, like all accounting firms, had a policy of retirement for partners at age 60. And at age 58, you started thinking about what did you want to do next, because most of us weren't ready to retire at 60, but that was the way the accounting firms had just set up their partnerships. So around age 58, I'm thinking, what am I going to do next? Because I'm probably not going to want to stop working in 2 years. And a vacancy became available on the DC Court of Appeals. And I thought, that really fits my background in a way. I mean, it's obviously a different court, but it fits my background of appellate litigation and the other side of the table or the other side of the bench from what I was used to, but that I would actually enjoy that. So I did apply for that, and the way DC judges are chosen, it's a presidential nomination, but there's first a judicial nominating commission that sends 3 names to the White House, and the president, by statute, under the DC home rule laws, has to pick one of those 3 names. You can't say I'd like to see more names. He has to pick one of those 3. So after meeting with the members of the Judicial Nominating Commission, they sent my name along with 2 others to then President George W. Bush, and he selected me from the list of 3. But it seemed as though it was very unlikely that I would get to the court, only because of the timing. It was very near the end of Bush's term, and there was a lame duck session of Congress to deal with what was then the 2008 financial crisis. And had that not happened, Congress would have been out of session until the next administration came in January. But because of the lame duck session to deal with the financial crisis, there were a lot of Hill staffers who were there with nothing to do but required to be in session. So they scheduled my hearing that otherwise my nomination would have lapsed, but they scheduled my hearing as something to keep the staff working while others were dealing with the financial crisis. And lo and behold, I had the hearing during the lame duck session of 2008, and was confirmed and joined the DC Court of Appeals in January of 2009. I wasn't quite 60, but because I knew I was going to have to retire in a year or so, the chairman understood that I could not and would not want to turn down the opportunity for the judgeship. And I found a lot of things I liked about the Supreme Court in my time in the SG's office, I saw replicated by being a judge on the DC Court of Appeals. We had a collegial group of judges who were way overworked. Just like when the Supreme Court had 150 cases a year instead of 75, the caseload for the DC Court of Appeals was kind of like a conveyor belt. It didn't matter how many days you stayed there. It's 7 a week. Cases just kept coming like a conveyor belt, more and more cases, and we never ran out of them, for sure. So there was that, for better or worse, that similarity, but also was the collegiality among the judges that I witnessed as a lawyer appearing before the Supreme Court. And I also witnessed the same collegiality, professionalism of the lawyers who appeared before us most often. The cases on the criminal side in particular, prosecuted by the U.S. Attorney's Office in D.C., which had excellent appellate advocates. And most of the defense lawyers that we loved to hear from were from the DC Public Defender's Office, which also had terrific lawyers. Many of those public defenders are now on the court I used to sit on before I retired. So I felt like in both cases, I was sort of home court. And was there one thing that I found surprising but really enjoyed about my time in the SG's office was when I appeared before the court, that was my home court as a lawyer to argue before. And I argued cases in circuits around the country as an appellate lawyer, but you would get a different panel of 3 judges every time. And you didn't feel like you knew them the way you got to know the Supreme Court justices and their preferences and who was going to ask difficult questions and who was not. It just became a comfortable relationship to feel like you could be helpful to that court because you understood them, they understood you. And the same thing was true on the DC Court of Appeals in terms of our relationships with the local lawyers who argued before us and the relationship among the judges.
Okay, your career is both impressive and so inspiring as a public servant, as a private practice attorney, in-house, in the judiciary. Thank you for your service, and thank you for letting us see a bit of that today. We really appreciate it.
Thank you. It's fun to talk to you.
The Historical Society is so glad to have been able to bring together these trailblazing women from the Solicitor General's office so we can hear and preserve the remarkable history of their legal careers. I want to close with an anecdote, though, about something that none of them bothered to prepare me for. It was the morning of my first argument in the Supreme Court, the Solicitor General's office. We go up to the Supreme Court in a van, everybody from OSG, and we went to the office that the Solicitor General has at the court. It's a very nice room there. Shortly before we're preparing to go into the courtroom, I go into the adjacent lawyer's lounge to use the restroom. So I walk up and realize there's a men's restroom, but not a women's restroom. I quickly change course and go out into the very long marble hallway and hurry down to the public restroom. I will admit, I cut straight to the front of that line, and it was a long line full of lawyers and tourists who were going to be going and watching the argument. I didn't say anything at that time, but I will say, very glad to note that a year or so later, the very large closet coat room in the lawyer's lounge was gone, and there was a very nice women's restroom there. More importantly, I'm so pleased to say that the Supreme Court never treated us differently, the women from the Solicitor General's office differently in arguments. The justices always relied on all the lawyers from the Solicitor General's office being thoroughly prepared and able to answer any and all questions they posed. Thank you again. Please check out the Supreme Court Historical Society's website at supremecourthistory.org. I guarantee you'll find all kinds of things of interest, and we invite you to join us as members. Thank you.